Morning, everybody. Welcome to the Courtroom Files Live. It is Thursday, the 4th of December, 2025. Just 3 weeks until Christmas. How about that? And for an extra Christmas treat, you get me filling in for the illustrious, often imitated, never duplicated Dan Soul. My name is Michael GROFF. We'll be with you for the next 3 hours or so, give or take. We will start our day in Florida. Why not? This is Judge Wade Mercer, first appearances.
Yes, sir. Perfect. We have one person that has friends or family here. So we'll call that case first. That is Samantha Yale. Miss Yale, good morning. Miss Yale, your mother, along with her friend Miss Collette, are both in the courtroom, ma'am. You're here because you've been accused of 1 count of first-degree misdemeanor theft, 4 counts of second-degree misdemeanor theft. These are all retail theft, and 1 count of scheme to defraud. That last charge is a felony charge, Miss Yale. There is probable cause for all 6 charges, ma'am. Miss Yale, your pretrial release sheet from the jail says that you're not on probation. Is that correct, ma'am?
Yes, sir, I'm not.
So how long have you been off of your federal probation?
A few months.
And you have no charges pending anywhere, correct?
No, sir.
Okay, that's good. That means you're going to be entitled to a bond unless there's something else I don't know. I'm going to listen to the attorneys, and I'll be glad to set your bond in this case. Mr. McNally, anything on behalf of Ms. Yale?
Your Honor, we just asked for a reasonable bond, and hopefully her mother, I don't know if her mother maybe wants to pay a cash bond, but just some kind of reasonable bond, maybe she get out and try to take care of this.
All right, Mr. Mitchell.
If she wants to do a cash bond, we have no objection to that, but obviously we ask for no contact with Walmart.
Okay. Thank you both. Ms. Yale, I'm going to set your bond at $2,500 each on your 5 misdemeanors, $5,000 on the felony. Those are pretty standard bonds, especially for someone that has a criminal history. You may have even been on federal probation when these charges allegedly occurred. They supposedly occurred in July and August of this year. So I'm talking to your mom now. I don't know when she got off probation, but these charges allegedly occurred late July and early and mid-August of 2025. Supposedly they're on video. So we'll see what happens when she comes to court. So your bond is $17,500. Now, if you prefer a cash bond, the state has said they have no objection to that. The advantage to a cash bond is if you post the cash bond, let me back up. If you go through a bondsman and you give them 10%, it was just kind of a normal charge. They negotiate, but that's kind of a norm. 10% will be $1,750. You won't get that back. It's gone. It's spent. If there's restitution allegedly owed, and if the state and defense agree, a lot of times I'll set a cash bond. So it's the same amount, $1,750. The difference is it's held by the clerk of court until we see how the case is resolved. Now, there's a statute that says if there's a cash bond, if there's a bond posted, that money has to be applied towards court costs and fines if there's court costs and fines or restitution ordered. So you still may not get it back. The difference is if I set a cash bond and the case is dismissed, you would get it back. Whereas if you pay a bondsman and it's dismissed, you still don't get it. So a cash bond, you can't. That's one disadvantage to a cash bond, and that's an advantage to a bondsman. So a bondsman may say, it's 10%, we're going to charge you 10%, but only 5% up front, and you can make payments on the other 5%. If you do a cash bond, it's that amount. There's no, the cash bond would be the equivalent of what you paid the bondsman. It'd be the 10%. So it's $1,750 cash. Or if you go through a bondsman, it's $17,500, and they may charge you $1,750. But if a bondsman very well may, I've heard of people say that bondsmen will take not all 10% up front. They may take 5% up front and let you pay the other 5% in payments. So if you, it's just a personal preference. The bondsman gets a fee for their services if you use them. If you don't use a bondsman, then they're not involved. Any preference on that? Miss Yale, your mother's thinking about the bondsman. Do you have anything you want to say?
Yes, Emmanuel, tell her Emmanuel. Peggy knows that's who we went through before with Jonathan.
So her bond is $17,500 cash or surety, and she has a condition to have no contact with any Walmart while this case is pending. You can't go to any Walmart at all while this case is pending, Ms. Yale.
Yes.
I'm going to ask the jail
sir.
to give you a notice for your court date. It should be January the 6th at 8:30 a.m. should be your court date in the circuit court. Do you have any questions, Ms. Yale?
No, sir.
In the courtroom, ma'am, do you have any questions?
What is Emmanuel's last name?
It's called Emmanuel bail bonds. I've just heard of Emmanuel bail bonds. That's what's got to be. That's what you're talking about, right, Michelle?
Yes, sir.
Emmanuel bail bonds.
I'm just fixing to have open heart surgery, and I think it's scheduled for the first of the year, so it's kind of like, I don't know, for some reason that comes up the same court date is, can it be rescheduled or something?
That's up to Judge Garcia, ma'am. And Judge Garcia is going to want, so if you get some medical documentation, if you have open heart surgery the same day as her court date, Judge Garcia, typically most judges are going to say they'll grant her a continuance to the next month, but I can't speak for her. She's going to want some medical documentation. At least I would want some medical documentation. She probably will also. You also may want to wait and see the videos before you decide if you're going to post bond or not, because if she really did these things on video, then that may be a factor for you to take into account whether you spend money posting bond for.
So how would I?
You'd have to wait till she got an attorney appointed. Then when she gets an attorney appointed, the attorney can get the video. She's entitled to see them.
Oh, okay.
Okay? Have a good day. Thank you for coming. We have Rhonda Weeks. Ms. Weeks, good morning. Ms. Weeks, you're here because you've been accused of one kind of petty theft. Ms. Weeks, this is listed as a failure to appear, but I believe I saw in the court file where the notice came back. So I don't know that it's a genuine failure to appear. I don't know that you got your notice, but Ms. Weeks, there clearly is probable cause for the charge. Supposedly, this was captured on video. I'm going to appoint the public defender's officer to represent you, Ms. Weeks. I'm going to ask that you listen to Mr. McDaniel, your attorney.
Your Honor, I spoke with this week. She's going to plead of no contest. She signed a plea waiver form waiving the right to a jury trial and call witnesses. The understanding should be sentenced to 6 months probation, $370 fine, restitution to $51.75, no contact with the homeowner or the home in question in the complaint, and that'll resolve this case today.
Thank you, Mr. McDaniel. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Ms. Weeks, did you hear that agreement?
I did.
Ms. Weeks, do you have any questions about that agreement?
No.
And ma'am, is that the plea that you would like to enter?
Yes.
Ms. Weeks, I'm going to accept your plea of no contest to the charge of petty theft, ma'am. Withhold adjudication of guilt, place you on probation for 6 months, ma'am. Sentence you to $370 court costs and fines. $51.75. That's not what's in the complaint, is it?
There's an invoice that was sent in later on that shows it being $51.75.
Okay.
So that's the official amount.
All right, thank you. So $51.75 restitution. The clerk's office is by statute can charge $3.50 clerk's fee per payment. So if you pay it all at one time, it'd only be one $3.50 payment fee. Ma'am, Miss Weeks, try to get everything done early so you can get off early. You've got to do half your probation. Everybody does, but at the halfway point, you will be possibly may get off early. Miss Weeks, what's going to happen next, ma'am, is they're going to let you use the phone to call friends or family for transportation. Then they're going to bring you to the courthouse. After you get back, rest back in your regular clothes. When you get to the courthouse, you'll meet with Mr. Goodson or Mr. Ham with the probation office. And once they explain everything to you and give you a chance to ask questions, Miss Weeks, you'll then be free to go. If you do call friends or family, you can tell them that you can be picked up in 30 to 45 minutes at the Jackson County Probation Office here at the courthouse. Ms. Weeks, do you have any questions?
No, sir.
Mr. Goodson, anything else?
Just for clarification, the victim's name is Christopher Scott Lyles. According to Mr. Mitchell, he got an address in Sneeze, and then he got an address in Naples. So I don't know what. Just for clarification for,
He may have moved to Naples.
I think the state attorney's office will have to get you an address. I don't know. That I'll order it payable to him that amount, but it's their job to get you the address to send it to you.
So no contact with him or any residents.
Yeah, no contact with that. No contact with that individual for sure. Okay. I'm not keeping you away from the apartment complex, especially if he's no longer there, but no contact with him at all. Ms. Williams, something else? It's not a retail theft. So since it's not a retail theft, I'm assuming there's not going to be a retail theft program. Is that accurate, Mr. Mitchell?
We're not requesting one.
Ms. Weeks, any questions, ma'am?
No, sir.
All right, man. Wish you the best. We have Gary Wilson next. Mr. Wilson, good morning. Mr. Wilson, you're here because you've been accused of violating the terms of your state probation The warrant that I've got a copy of is signed by the circuit judge, Judge Garcia, and it has no bond. Mr. Wilson, I'm going to arraign you this morning. We do that at first appearance if there's an affidavit filed by the probation officer because we want to get you a lawyer appointed if you want one. Mr. Wilson, would you like to have an attorney appointed to represent you?
Yes, sir.
I'm going to appoint the public defender's office of the 14th Circuit to represent you. Listen to Mr. McDaniel, please.
Your Honor, we're going to plea of not guilty as to sentence on January 8th, and I advise you, Mr. Green, come by and talk to him prior to that hearing.
Thank you. Mr. Mitchell, anything in that case?
No, Your Honor.
So, Mr. Wilson, Mr. Green will see you before your court date. Any questions?
No, sir.
Have a good day, sir.
I'll be here at Livingston.
Next case we have is Destiny Broadnax.
I'll do her last.
Okay, that brings us to Jack Xavier Livingston. Mr. Livingston, good morning. Mr. Livingston, you've been here because you've been accused of one count of grand theft of a firearm and one count of possession of firearm by a juvenile delinquent. Mr. Livingston, looks like they bumped this up to adult court. When I say they, I mean the state attorney's office has charged you as an adult. Mr. Livingston, there is probable cause in the complaint, and I want to listen to the attorneys before I set your bond, sir. Mr. McDaniel, anything on behalf of Mr. Livingston?
We just asked for a reasonable bond.
Mr. Mitchell?
We're okay with a reasonable bond and the condition of no firearms.
Mr. Livingston, I'm going to set your bond on the third-degree felony grand theft at $5,000, on the possession of firearm at $10,000. Mr. Livingston, your total bond is $15,000 cash or surety. You do have a condition not to possess any firearm while the case is pending. You also have a condition to have no contact with the alleged victim. Mr. Livingston, you'll get to use the phone in a few minutes, sir, to try to post a bond. Do you have any questions?
No, sir.
All right, Mr. Livingston, wish you the best. So that was 15,000 total.
It's the Courtroom Files Live. It's Thursday. Welcome. Good morning. Michael Groff filling in for Dan Soul. And he'll be back tomorrow. Don't worry about that. But in the meantime, we're just hanging out here and watching some first appearances with Wade Mercer in Florida.
Your attorney, Mr. McDaniel.
Your Honor, I spoke to Ms. Broadnax in 24415 MM. We're going to enter a plea of no contest to the charges listed. She has signed a plea waiver form, waiving right to a jury trial and call witnesses.
So it's a straight up plea.
Yes, Your Honor.
Ms. Broadnax, let me get you to raise your right hand, ma'am. Do you solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but truth, so help you God?
Yes, sir.
Okay, so Ms. Broadnax, you're here on this charge that you're aware of, ma'am, accused of one count of petty theft. Ms. Broadnax, I've read the complaint, so I'm familiar with what the allegations are. You need to understand you have the right to a jury trial or a trial. In most cases, the right to a jury trial, but you've certainly got a right to a trial either in front of a judge or jury. If you exercise that right, you get appointed attorney, probably be Mr. McDaniel, someone with the public defender's office, and then you would get a chance to call and cross-examine witnesses at that trial. Do you understand that, ma'am?
I do.
You have the right to the trial and you have those other rights I just mentioned. Do you understand those rights?
Yes, sir.
But if you enter this plea, you're waiving those rights. There will not be a trial. You don't get to call witnesses. You don't get to cross-examine witnesses. I will listen to you. I'll listen to Mr. McDaniel. I'll listen to Mr. Mitchell with the state, and I'll decide what sentence to impose today, and there won't be a trial. You'll be waiving those rights. Do you understand that?
Yes, sir.
Do you also understand the maximum penalty for this charge is 60 days in the county jail? That's the maximum I can sentence you to. Do you understand that?
Yes, sir.
Okay. Do you have any questions you want to ask me before you enter that plea?
No,
Questions?
no, I do not.
So
No,
the
I
plea,
have
Mr. McDaniels wants to enter, that's put on the record, a plea of no contest, knowing everything I've told you. Is that the plea you would like to enter?
Yes, sir.
Okay, so I'm going to accept your plea of no contest to the charge of petty theft with the advice of counsel. Now I'm ready to proceed to sentencing. So Ms. Broadnax, anything you want to tell me you think I need to know about the case, I'm glad to listen, or Mr. McDaniel.
Judge, I spoke with Mr. Broadnax and I, looked up her history and whatnot. She did turn herself in. She come back, turned herself in. Her mother lives in Greenwood and she's living there at her mother's house. Her only history she has, I think, is maybe a disorderly conduct or something from another state some time ago. We just asked the court to take those things in consideration, and Ms. Broadnax is going to make a statement.
Your Honor, at the time of my arrest last year and a half ago, I was under the influence of drugs and alcohol, and I was also in a very abusive relationship. and homeless. So then, like, his best idea for me was to just leave the state and flee this, because that's what my ex would do with all his charges. And me, I didn't know any better. I'm not trying to say like that it's all his fault or anything. I did know better, but I was scared of being homeless and all that. So I joined the carnival, and I've been doing that for the last year and a half. I'm finally done with that and done with my ex, and I want to just be with my family. And I just found out I'm pregnant, and I want to, get out as soon as I can so I could get a job and start providing for this potential baby that I'm having.
Okay. Ms. Broadnax, Mr. McDaniel made a comment about your prior criminal history that doesn't match what I've got in front of me. So it sounds like there may be something you haven't told him about. So I'm going to ask you, when's the last time you were charged with a crime?
In Boaz, Alabama. And then I got picked up on a warrant in Georgia.
Okay. When was the last
morning.
time you were charged with a crime? That's what I'm asking you, the last time.
Like Illinois, maybe. I was like
3 days
5 years
after Christmas, 3 days after Christmas last year. Do you remember a burglary in Lake County? Looks like IN. That may be Indiana. Do you remember that one?
Yep, no, I do. I
Okay.
didn't at the moment, sir. I'm so sorry.
Yeah. So,
I-
Mr. McDaniel, I think there's some criminal history. There may be some more things on here that's more than just what
No, I
she's got
forgot
in
about that.
Florida. So anything else you want me to be aware of, ma'am?
I am sorry. I forgot about that one. That wasn't even, it's criminal trespassing was on there, right? Is on there as
It
well?
was burglary, but it may have been reduced to something else. I don't show a disposition. I don't know.
So my ex that I was with, he brought me back to Indiana when we were on winter season from the carnival. And he thought it was a good idea to break into his mother and stepfather's house they were selling because we had nowhere else to go. And so that's what happened. I got caught up on that, and
Is the
I have
eggs
no
that you
idea, to be
keep,
honest.
the eggs that you keep referring to that you're blaming for a lot of your troubles, is that the same person who was with you at the dollar store in the current case?
Hunter James Polly, yes.
Okay, and in the current case, you told the officer, according to the complaint, he had nothing to do with this particular theft. That was all you. And the
Yeah,
video
he
seemed
didn't
to
have
confirm
anything to
that.
do with the theft. He didn't have anything to do with the theft. He
So
just got trespassing on that.
It makes me wonder who is the bad influence on whom. If the video shows you stealing stuff and him being in the store and paying for his, but now you're telling me he's the bad influence. I'm not fully convinced of that. Anything else you think I need to know, ma'am?
I mean, the last time I was here, if you look at my IDs, I had marks all over my body. They were trying to get me to admit domestic violence at the time with him, but I wouldn't because I was still in love with him. I was just doing as I was told in that time, Your Honor.
Okay.
Yes. I just asked
Thank
for a
you, ma'am.
second chance, please.
Thank you, ma'am. Mr. Mitchell, anything on behalf of the state?
Just a second, Your Honor. Nothing at this time, Your Honor.
Ms. Broadnax, having heard from you, ma'am, looked at your history and read the complaint this morning. I'm going to sentence you to 60 days in the Jackson County Jail. It's been a year. You took off, disappeared for 1 year on us. I would be foolish to put you on probation and think you're going to show back up. So I'm going to sentence you to 60 days in jail. I'm going to give you credit for the time that you've served. You're entitled to that credit. Mr. McDaniel, how much time is that?
3 days jail credit. And I
3
was
days
hoping,
credit, Miss.
3 days.
I'm sorry, I couldn't hear you.
I was hoping Your Honor might consider 30 days. That's what my hope was, and that's up to you.
60 days in jail is her sentence. 3 days credit. Court costs and fines are imposed in the standard amount of $370. No probation involved, Ms. Broadnax. I do wish you the best, ma'am, but I'm not convinced by your testimony or your arrest since this incident that you've rehabilitated in a significant manner. I do appreciate you turning yourself in, but it's a year too late. So, Ms. Broadnax, I wish you the best, ma'am. I'm not going to any
Yes, sir.
restitution given the jail sentence. It was 2 bottles of wine. The officer didn't even put the amount of the wine in the complaint. So I'm not sure. It could have been a first degree misdemeanor, but the officer chose not to tell us the amount of the wine that was stolen. So Corporal, that's everything I had on my list. Anything else from the jail this morning?
No, sir. Just to let you know, they know wine at the dollar store worth over $100.
I have no idea. I'm not a drinker. So they don't have a wine. It was 2 bottles. So they don't have a wine on the shelf that costs more than $50. But don't
They don't
shake
have
her
wine on
head
the shelf
no, and she would know for sure. So
We'll have wine on the shelf
I'll
cost more
take
than
y'all's word
$5.
for that.
We'll have wine that costs more than $5, just to let you know. So, yeah.
Okay. All right. Thank you for letting me know that. Mr. McDaniel, anything else from the public defender's office?
No, Your Honor.
Well, that seems to be a wrap for Florida, for Wade Mercer and first appearances. So let's head over to Michigan. Let's see what's going on with Judge Dad.
25T64708 A, B, and C. Good morning, ma'am. Your name? You're charged with driving on a suspended, using a handheld mobile device while operating a vehicle and expired plate. You have the right to an attorney. If you want one, I will give you one. Would you like a lawyer? Okay, I'll go ahead and arraign you and then I'll send you to the prosecutor, okay? It is alleged that on November 13 of 25 that you were operating a motor vehicle in the city of Trenton, county of Wayne, on King near Breland at 3:50 p.m. with a suspended license that is a misdemeanor punishable by up to 500 fines, 93 days jail. Costs are all those and 2 points. You also have this using a mobile device while operating a motor vehicle. That's a civil infraction, as is expired plate. Do you understand that? I'm sorry?
Yeah.
Did you sign the advice of rights form and read it and understand it? If you plead guilty to driving on a suspended, you'll be giving up all those rights, and we're not going to have a trial. Do you understand that? Okay. I'll enter a not guilty plea. You still wish to waive your right to a lawyer?
Yes.
I'll enter a not guilty plea, $500 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. You're going to go over to the into the hallway. My courthouse is going to bring that file to the prosecutor. Prosecutor will come out and get you, speak to you, and if you don't like what they're offering, you can go ahead and give me a you can go ahead and give me I'm sorry, looking at this file. You can go ahead and tell me you want a lawyer, in which case I'll appoint you one, okay? All right, thanks. Daniel A. Lumen? Do I have the 25M117656? Okay, this is with the special prosecutor. All right, good morning, Mr. Kessel. How are you? Good.
How are you?
Good. Your appearance, please.
Yes, thank you. Good morning, Your Honor. Assistant AG Chris Kessel for the people.
Ms. Lumen, your name, ma'am?
Danielle Lumen.
Good morning, Ms. Barkovich.
Yes, good morning, Judge Camilla Barkovic, appearing on behalf of Miss Lumen.
What are we doing on this? This is just a PCC and we got the exam scheduled for the 10th.
That's
Judge-
correct, Judge.
Judge, I was going to say real quick, I had the good fortune to run into Miss Barkovic the other day in Troy. I know she's going to demand the exam. There's a witness, let's say, that I'm having some trouble locating. If I cannot locate this witness, then the people would not be able to proceed. What I will do is, and I've told Ms. Barkovic this, the day before, or maybe the Tuesday before the exam, because I think it's scheduled for Thursday, I'll reach out to her and let the court know where we're at. With the court's permission, if we're not ready to proceed, would the court allow us to appear via Zoom just for Ms. to let the court know we're not ready, Ms. Barkovic to move? Obviously, if we are ready to proceed, we'll all be there.
No problem. Everybody should plan on attending, but if that's the case, you guys got a coordinated time. I'll work with you in terms of, you putting all this on record, and you have to just coordinate a time between the three of you, and I can work with you. Okay.
Fantastic.
All right. So as of now, we'll proceed to the exam on December the 10th at 1 p.m. Okay.
Thank you so much.
Have a nice day, everybody. Thank you.
Thanks so much.
You too, Judge.
Thank you, Judge.
Bye. Jonathan Johnson. Jonathan Patrick Johnson. Your name?
Jonathan Johnson.
Boy, am I disappointed. I'm giving you a lawyer right now. Hang on. Let's not say a word. Don't say a word. I'm going to give you a lawyer right now. Okay? So you go sit down out in the hallway. John, set him up with whoever,
I got it.
and then we'll take care of it. Fernandez, Derek Tan Galda Fernandez, 25W707530. Your name?
Derek Fernandez.
I got two charges here. Call in, Jessica. Fair to attend the domestic violence program one day on October 7th. And fair to provide proof of completing 31 hours of community service by October 20. That is the those are the two charges. If you plead guilty or if you're found guilty, your 7694A status could be revoked. And you could get 10 days jail. You understand that? I can't hear you.
Yes.
Did you sign the advice of rights and read and understand the rights?
Yes.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing. Do you understand that?
Yes.
You have the right to a lawyer. I'll be happy to provide you with one at public expense. Would you like a lawyer?
Yes.
We're gonna get you a lawyer. And I gotta tell you, she told me you did the domestic violence program. That was a bizarre letter that you sent to the whoever it was that you were conferring with about going to the domestic violence program. And I don't even know what to say. That isn't how you write your name, is it? With a penis?
It's fast, but
I don't, listen. Are you kidding me? Are you kidding me? That's your signature? Maybe you should change your signature. I write horribly, but I mean, I'm gonna give him a lawyer. He wants a lawyer. We'll give him a lawyer and then we'll cover this, okay? Thank you.
it's home.
Jeez, oh Pete. What's going on here anymore? Winkleman, Natalie Susan Winkleman, 25G 306771. I get it. I just don't get it. Your charts, ma'am, your name?
Say that again.
Your name?
Natalie Winkleman.
You're charged with drive while license expired and you have the right to an attorney. If you want one, I will give you one.
Okay.
Do you want a lawyer?
No.
Okay, I'll go ahead and arraign you, and then I'll send you to the prosecutor. You're charged with operating a motor vehicle on November 15 of 25. While your license was expired, that is a misdemeanor. It is punishable by up to $100 fines, 90 days jail, costs for all those, and 2 points. Do you understand that? And did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights. There'll be no hearing or trial. Do you understand that?
Yes.
All right, so you still wish to waive your right to a lawyer? I'm gonna enter a not guilty plea, $100 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. You're gonna go down the hall and we're gonna set you up with the prosecutor, okay? And you'll go talk to the prosecutor. Either way, you're coming back in front of me, okay? All right, thank you. Marion Curio Banks, 24F 242-000A and B. Mr. Banks, good morning. Your name?
Marion Banks.
All right, counsel, we notified the victims, Cheryl Melton and Brooklyn Gillenkirk. Are either one of them, they're not in the courtroom because there's nobody else in here other than us and the three of us and court staff. And do you have anybody out there, Lisa, by either the name of Cheryl Melton or Brooklyn Gillenkirk?
I have an iPad that I've been unable to identify.
Okay,
I'll bring it in.
iPad, can you unmute iPad 108? Can you unmute, please, and tell us your name?
All right,
Okay,
hello, can you hear me?
I can. What's your name?
John Gruball.
What are you here on?
Speeding ticket, Your Honor.
Do you,
I think I got the ticket number here, Your Honor.
It's a department rep, Judge. I'll move them.
Okay, they're gonna move you, when you come back into court, have your hat off for me, please, will you? Thank you.
All right, no problem.
Thank
Your
you.
Honor. Mhm.
All right, so it looks like none of the victims have appeared. I did read an impact statement that was sent. Did you have a chance to review that with him?
We have reviewed it, Judge. I just want to make sure that that was the only statement submitted from Ms. Kerr.
Yes.
Okay.
Yes.
You've had a chance to review.
Okay. All right, what would you like to say?
Judge, I discussed this matter with Mr. Banks. Obviously, Mr. Banks is 24 years old, Judge. His girlfriend just recently gave birth to a daughter, a 2-month-old.
You're the father, obviously, right?
He just became a new father, Judge.
Congratulations.
Thank you.
Do you have any other children?
That's good.
All right, be a good dad, okay?
Judge, he's currently employed at McDonald's. He just got that job a few days ago, but prior to that, he was working at Home Base, which is a siding and custom trim company. He's done that for 3 years. The reason he left was because the work was seasonal, and during the winter, it's difficult to find jobs and actually be outside. I spoke to him about the incident, Judge. He said it. He didn't realize that he hit the victim twice. The reason that he tried to leave the scene was because he was scared he did not have a valid license. And so that was the main reason. There was no intent here to actually ram or harm the other individual deliberately. He's currently in the process, Judge, of looking for an attorney to help him get his license reinstated so that this episode doesn't repeat itself. And at the time this happened, Judge, this happened back in 2024. He's young, he's 24, but he was younger, and in hindsight, it's 2020. He understands what he did is wrong, and now his priorities have changed since his daughter's been born, Judge. And he understands that he needs to be a good role model, good dad for his daughter, and obviously he regrets what happened. Isn't that correct? Yes, sir.
All right, what would you like to tell?
So you guys, sorry. It was not supposed to happen.
I know. Then you left the scene and then you didn't show up for sentencing. This case is still going on. In April of 24, because you didn't show up. Did he spend any time? He didn't spend any time in jail, did he? Well, when I set the bond of 5,000, 10% back in November 13th, did you spend any amount of time in custody then? Were you here in person? You were, weren't you?
Yes, sir.
We didn't take you into the back?
No.
You just walked out
Yes, sir.
and then you posted a surety bill. Why'd you walk out? You have no clue.
Were you told to stay and everything? No, I wasn't.
So when is the last day that you worked at any time?
Yesterday
And where'd you work?
at McDonald's.
Okay.
It's been an argument, 11 to 11,
How many hours do you work there?
4 times.
Okay, so you're going all the way from Grosse Ile to Ann Arbor every day?
Detroit.
You don't live on East River anymore.
Well, that's my another address.
You gotta have your regular address registered with the Secretary of State, not your mailing address. You follow me? So right now, you need to go change your address with the Secretary of State and give them your true address, not your mailing address, okay? All right, here's what I'll do. On the suspend charge, $100 fines.
Ticket.
200 costs, 75 victims' rights, $50 justice assessment, 4 1/4 of 93 days. On the other case, 100 fines, 75 costs, 75 victims' rights, $50 justice assessment, 300 or 90 days, 7.25 is your total.
We're gonna require payment.
Does he have anything today?
No.
Okay. Now I'm gonna set up a payment plan for you and I'll let you set your own payment. As long as it's reasonable. And if you don't have the money, you're gonna call the court, we're gonna go on Zoom, or you're gonna have to come out and talk to me on or before the due date at 8:30 in the morning, okay?
Yes, sir.
I don't mind giving you extensions. You don't need to be scared. I don't care how many times we have to do it. But don't ignore me again, all right?
Yes, sir.
Okay. Tell me how much you can afford to pay. You get paid weekly or bi-weekly?
Bi-weekly.
Okay, when do you get paid next?
2 weeks from now. 2 weeks from Friday.
2 weeks from Friday. Okay, so that will be 2 weeks from Friday?
Well, because he just started, Judge. I believe they keep the first week and then they begin to pay them bi-weekly during the second.
All right, so you're gonna get paid on the 19th, right? Well, you got that child. You wanna have a nice Christmas. So how much can you pay bi-weekly?
At least $100.
I don't need you to pay $100. You pay $50 bi-weekly, and I'm gonna start that on the B file. And you're gonna do 1 day of community service, by the way. You have to do 8 hours of community service on that failure to report, and I'm gonna give you until January 31 to complete that. You can do that at any nonprofit organization, Salvation Army, St. Vincent de Paul, animal shelter, a church, I could care less. 8 hours. You're gonna pay $50 bi-weekly, and I'm not gonna start that until, I'll tell you what, I'll start at January 26th. And again, if you don't have the money, what are you gonna do? I'm not gonna get on the phone with you. You can call the court, say, I'd like to get on Zoom with the judge, okay?
Okay.
You know how to operate Zoom?
Yes, sir.
Okay, so we can do it by Zoom and
There's community service, just make sure
that will,
you're let on whatever you do it.
that will get you out of here, okay? So I expect you to make the payments. Again, if you don't have the money, go on Zoom. I'll give you an extension. I don't care how many times we have to do it. Just don't ignore me, please.
Just for clarification, right, the due date on community service?
January 26th. Oh, wait a minute.
The same day that the.
Wait a minute. Wait. What did I say? My apologies. I think I said the 31st. Yeah, 31st is when the community service is due, January. All right? It's only 8 hours, so get on that though, all right?
Okay.
Good luck. Wish you well.
Thank you.
Have a good day. Be a good dad. Good luck. 20.
Nice words from Judge McNally. Good morning. It's the Courtroom Files Live. Thank you so much for joining me here. Thursday, the 4th of December. And we're monitoring, a couple of dozen courts right now. There's a lot going on. And obviously in Judge McNally's court, well, we had pretty routine stuff. You know, a guy signing his name by drawing a penis. Pretty normal stuff. Typical stuff in Judge McNally's court. All right. Let's head to, let's see here. Where should we go next? I know. It's our commitment here at the Courtroom Files Live to give you at least 9 to 11% more Judge Boyd. So with that being said, here's Judge Boyd.
All right, the court is calling 2025 CR 013212, State versus Joe Anthony Garcia. Could I have parties approach and announce for the record? All right. And are you Joe Anthony Garcia?
Yes, ma'am.
All right. You entered into a plea on November 18th. Both parties agreed to waive PSI and the TAP evaluation. According to your plea bargaining agreement, punishment is to be assessed at a cap of 8 years in the prison, and the state is silent on your applications. All right, defense, do you have any witnesses?
No, Your Honor, only allocution.
All right. You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
John Anthony Garcia.
All right, defense, you may proceed.
What prompted you to burglarize that house?
I needed to shower, because my stepmother's, my father lived there with my stepmother. So he said anytime I needed to go shower, you just go there. And my dad, Joe Garcia, he had left, got arrested by the U.S. Marshals. She kind of started acting different, like changing up her mood and telling me I couldn't be able to go there. And then the next day, she would tell me I was able to go there. She'd give me food and stuff like that. At the time, I was homeless. I seek the Haven for Hope, which I still am seeking now to this day, and it's been kind of, but it was kind of hard. So I went back one last time to see if I could shower inside and get some food and get some rest, because I like to be outside a lot. And she wasn't there, so I kept knocking on the door. Went to the window, the side of the door, knocked on that side, and kept going back and forth. I went back the last time to the door, and the door was propped open. So I was like, huh, okay. So I went inside, me thinking it was unlocked for me. So I went inside, and I went to go take a shower, and after that, I went back. I left out. But
Well, any other questions?
Were you intoxicated at the time?
No, sir.
Did you have a job at the time?
Yes, sir, I did. I worked at Rent Hill Staffing.
If she gives you deferred adjudication, can you go back there for your job?
Yes, sir, I can.
Are you sorry for what you did?
I'm very sorry. I'm really not a bad person. I really do stay out of trouble. I do respect everybody. You know, it was just at that time I was going through a moment with my dad and my stepmother. But I really definitely did learn my lesson. Being incarcerated as long as I've ever been locked up, and I really don't like it. It's not for me.
Nothing further, Your Honor.
All right. So let me just tell you what the summary says. It says that the front door to the home or to the residence, because I don't know if this is an apartment or not, had been damaged because the U.S. Marshals raided the apartment. So I'm assuming the U.S. Marshals kicked in the doors and nobody ever repaired the door. So she states, while she was asleep, you entered the residence and stole property from the location. So it's not that you entered the residence and took a shower, it's you entered the residence and stole property. And she received notification that someone was trying to use her stolen credit cards. So you want to speak to that?
Yes, ma'am. I'll speak to that.
Yes, please do.
Yes, I did take the credit cards
Why?
because I was hungry.
Was your name on the credit card?
No, ma'am, it wasn't.
So did anybody give you permission to take a credit card?
No, ma'am.
So this wasn't you just coming in to take a shower and leave. This was you coming in and you knew that, according to your testimony, you knew that the U.S. Marshals had already raided that apartment.
No, ma'am, I did not know that.
So when did you discover that the U.S. Marshals had raided?
I had found out when I saw it on her notepad saying finally the U.S. Marshals came and got my dad.
All right. And so that was a notepad in the home?
Yes, ma'am.
So that means that, again, you were not just in that apartment to take a shower. You were in that apartment looking around for things. And what it says on here is, Mr. Garcia, because he is the son of Miss Tobias' ex-significant other. So that part of your testimony is true. She stated that she had video surveillance that shows you moving the camera so it wouldn't catch you taking property. It's odd that in here, there's no listing of you taking a shower, because it says that when you entered this apartment, she was asleep. I don't know how big this apartment is where people don't know someone else is in their location with them. But She said that she was asleep. No mention of you ever taking a shower in any of these police reports. Did you ever give a statement to the police stating that you had taken a shower?
No, ma'am.
So there's nothing in here about this shower business. The only thing that's in here is that you came into that apartment and it was easy for you to come into the apartment because the US Marshals, I'm assuming, kicked in the door, damaged the frame, and the door was sort of propped. So that part of your testimony is true. It's sort of propped open. But you went in and you were moving surveillance cameras around and taking things that did not belong to you. Discuss.
The property was in her room. I went to go knock on her door. She was my stepmother and my dad. My dad has a history of doing heroin. All right, he's a drug. So my stepmother is the same way. I went in her room. She goes,
Oh, you're saying she's a heroin user,
she is. I'm not gonna lie. I'm not gonna sit here and lie on camera either.
but she has a place to stay
She does.
and she has credit cards.
She does because of my dad.
Okay.
She does because of my dad. And I went to go knock on the door. She was knocked out. I was, just tapped on her shoulder and everything. And she was still knocked out on the bed. No response. And I saw another dude in my dad's bed with her. So it that's why I did everything I did right there at that moment. So it kind of threw me off.
So now you're saying that when you came into the apartment after having knocked on doors, you go in, you see her in the bed, you tap her on her shoulder to try to wake her up, and then you notice there's a man in bed with her. Did you tap him on his shoulder as well?
Yes, ma'am, I did.
So-
I knew both of them.
Oh, so you tap him on his shoulder.
He gave me a response. He said the door is unlocked for me.
Oh, this story keeps
Well,
keep adding to the story. So when you tapped him on the shoulder, he says the door's unlocked for you.
yes, ma'am. That's how I got in there, took a shower.
Oh, and who is this person?
I don't know his name like that.
But you said you know him.
It's his street name,
Oh, what's his street name?
Joker.
Joker. Okay. Continue, please.
So I went to go take a shower, and then I get out the shower and I go in the room and so I'm leaving. Then after that I left.
All right. Well, any other questions?
Oh, Your Honor.
Well, according to your plea bargain agreement, the state is silent, but the state always reserves the right to address any issues that may be untruthful. So state, any questions?
I was gonna find the exact about Judge, but there is no mention in his original allocution of the credit cards. And that he said he was staying out of trouble, or he tends to stay out of trouble, but he does have the criminal history beyond just this.
All right. And what is the criminal history?
No, Your Honor, she's supposed to stay silent. That's not.
No, part of the PSI and TAP evaluation, I always say that anybody can bring whatever witnesses they want to bring. And one of the things I would need would be criminal history. But if you all want, I can reset it for a PSI and TAP evaluation to obtain that.
No, Your Honor, you're gonna find out one way or the other.
All right. What is the criminal history? And please, only the convictions. And counsel, if you want to review what they have with regards to criminal history.
No, Your Honor.
Okay. Oh, well, defense, would you like to tell me or?
No, Your Honor.
Okay.
Has a theft conviction 100 to 750 from August 25th of 2022. The terroristic threat conviction from January 16th of 2025. And that's
Oh, okay. And has anyone spoken to the complainant?
we did make efforts to reach out to her, Your Honor. We were unsuccessful.
Okay. All right. That tells me a little something. So how often have you been using? And you need to be honest with me.
Marijuana.
Everything. Don't just come to me with, I only use marijuana.
Marijuana I've been using, well, for about 5 years.
All right. And other drugs?
Meth I've been using about just 1 year. when I met this girl.
And when did you start using meth? You say 1
Last
year.
Last year,
And how old are you?
28.
And why did you start using meth? last year?
I met her in the streets.
Who did you meet in the streets?
My girlfriend. It's a girl that I met, but we're not together no more.
And what are all the tattoos with the numbers about?
This is my birth year, 1997. This, yeah,
And that's what?
a little money bag.
Mhm.
And this is money, power, and weed.
Money, power, and weed.
Yeah.
All right. Have you ever?
I got these when I was young.
All right. Thank you. All right. State, you may be excused. Have you ever had any mental health diagnosis?
No more.
And where's your mom?
My mother, I was in foster care, but my mother, I never got to meet my real mother. My stepmother, Joanne Pearson, she's on 4006, 4006.
No, I don't need the address or anything. But I'm just trying to figure out what has happened in your life that you're now before me, having now addicted to meth, using marijuana on a daily basis, going to this apartment where your stepmother is, and your father, I'm assuming, is in federal custody.
I've been alone all my life, like that. I got out of CPS at 17 years old, and after that, it's been.
And did you even try to sign up for college? You know they give that to you for free when you're in the foster system.
I did sign up for college, but I didn't get to go.
Well, here's the thing. When you're in foster care, depending on when you did that, you still may be entitled to free college. You need to look into that. And sometimes people don't want to go to college, that's fine. But they have extended it to where you can get your trade certification in something, all right?
It's fine.
All right, here's the thing. I'm going to give you a choice today. And these are your only choices. Don't ask me for anything else. And if you want to speak to your attorney about what would be the best decision possibly for you to make, you can do that. The state is asking for a cap of 8 years. I'm taking in consideration all of your testimony. I will sentence you either to 3 years in the prison, or I will give you your application for deferred adjudication. If I grant your application for deferred adjudication, and if you're unsuccessful, you're looking at potentially 20 years in the prison. Do you understand?
Yes, ma'am.
Do you wish to speak to your attorney?
I'll take the deferred.
All right. Ms. Abrams, are you ready?
Yes, ma'am.
All right. The court will sentence you to 6 years deferred adjudication.
Yes, ma'am. I'll let you down.
All right. There's a $2,000 fine that will be probated. There's to be a TAP evaluation in custody. Follow recommendations. Regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 45 days. No employment as a home health care provider or with minors. Field visits 1 time per month until further notice. And the proof of employment will be 45 days within release of custody. There's to be no contact with Janelle, Janelle Tobias. There's to be 300 hours of community service restitution. One hour will be deducted for every sober support meeting completed. I'm going to order 60 sober meetings in 60 days. And you're either going to obtain a trade school certification in something to better yourself, or either you're going to college. You understand? So either a trade school certification or enrollment in college. I want you to be able to have some kind of means of supporting yourself. And maybe the best way for you is to get your trade certification. What I can tell you, sometimes people will look at criminal history and it doesn't go well with you finding employment. One certification though, that people always need, believe it or not, they always need welders. So that would probably be a good profession for you. But again, find whatever your passion is and follow it. You understand?
Yes, ma'am.
As long as it's legal. All right, probation, is there anything else that's needed? Is there anything else you need from the court in order to be successful?
No, no.
All right, and probation, could you see about helping him with housing? And I would do just hold in abeyance the referral to felony drug court. I know their graduation is not coming up for a while and they don't have any room, but if you could always just have that there for him. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Counsel, here you go. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. You understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing, from here on out, everything that you do, you need to ask yourself, is this something that could potentially result in me going to prison for 20 years? If it is, don't do it. If it's, it could be, don't do it. In this court, to be successful on probation, communication is key. If there's an issue, let your probation officer know about it. If you feel they're not addressing it, you can come back to court. If you are out and about and you feel the stresses of life are getting to you and you think you're going to use, don't use. Contact your sponsor. If you can't contact your sponsor, call your probation officer. Trust me, if you call your probation officer and say, I'm thinking about using, what's going to end up happening is they're going to let me know. I'm going to have you brought into court and we're going to see what programs or what we can do to help you. But do not disappear and do not just say, oh, I started using, so therefore I'm not doing anything anymore. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
And don't do any more the tattoos, money, power, and weed. That's not a good tattoo. Okay.
All right. Thank you.
You're welcome.
Thank you, Judge.
Thank you. And
Uh,
Ms. Abrams, can you also see if there's any trauma issues with him? All right, thank you.
Money, power, and weed. One of those things is not like the other. All right, well, that's Judge Boyd. Good to check in on her. It's the Courtroom Files Live. It's Thursday. Michael Groff sitting in for Dan Soul. He'll be back tomorrow. Let's see. Let's go over to, as I'm, again, monitoring a bunch of courts here, but let's see what's happening with Judge Middleton. It looks like he's got a hearing that's getting underway here, so let's see what that's all about. He had a very interesting traffic hearing yesterday, so let's see what he's got going.
We've got everybody, I guess, at least enough to get started. These are two zoning violation matters for a property out on Patterson Lane in Lockport Township. Defendant James Bryan, Bryan, is present in the courtroom. His file number is 252205. Connie Merriman is not present. Her file number is 2422040N. She called and said she was on the way here, but the roads were bad. They aren't that bad. And then she didn't appear, but then I was told that her son would be here, and apparently he is here. What's your name, sir? Charles Worthington? Is some of this stuff on this Patterson Lane property yours? Mr. David Zemansky is here for the plaintiff.
Your Honor, Trent Cunningham. I was with David last time.
I think I may have called him Trent one time. Trent Cunningham is here from, so tell him next time I see him, I'll call him Trent. Trent Cunningham is here on behalf of Lockport Township, as well as Dylan Aruda, also from the plaintiff's law firm. Also, Mike Hayden, zoning enforcement officer for Lockport Township. All right, let's go back to square one here. Let me pull these up. The defendants got cited for zoning violations for this property at 57901 Patterson Lane. The court is aware that Patterson Lane is a dead-end road that runs north and south from M60, I think, to the west of Three Rivers Airport. It's probably 3/4 of a mile long. It runs off the highway and dead ends, and we've had a number of zoning cases involving that short piece of township. The ticket the defendants got was issued on December 9th of 2024. It alleges that they are in violation of the building interim property maintenance code for multiple violations: recreational vehicles, RVs being occupied and or lived in, unlicensed and inoperable motor vehicles, RVs, junk, and other nuisance items stored on the property in violation of the township ordinance. And a number of pictures were attached. And this property, at least from the photographs, is as bad as anything I've seen in a while. So anyway, as I indicated, that citation was issued last February. The plaintiff has filed a hearing to show cause why the ordinance should not be enforced. Mr. Cunningham, what's the township's position here?
Thank you, Your Honor. The township's position is that an order was entered, as the court just noted, in June, pursuant to the defendant being found being defaulted, I believe, at an informal hearing. We submitted a compliance order, which this court entered back in June, which gave the defendant 30 days to clean up the property and to remove the items that Your Honor just noted, the RVs and the junk and the other nuisance items on the property. The township's position is that this has not been cleaned up despite the order being entered back in June, which led to the township filing its motion for contempt and leading to this show cause hearing. The township's position is that the property has not been cleaned up, and we don't see a path forward to get it cleaned up or to have voluntary compliance by the defendant's part to comply with the court's order. And so we're here seeking this court to enter a subsequent order that would allow the township to abate the property pursuant to this court's equitable authority in civil infraction cases, as I know this court is well aware. So the main thing we would want is equitable authority to abate the property pursuant to statute, then be allowed to charge a lien on the property if those costs of the cleanup go unpaid, as well as the fact that we're here on a motion for contempt, which statute authorizes the township to seek our attorney's fees and costs that we have to get us to this point and to have the show cause hearing and to appear here today. We would also ask that Mike's fees for prosecuting this violation related to the show cause hearing would also be reimbursed as well and charged to the property as a lien if the defendant is unable to pay that within a certain amount of time. We're here prepared to present testimony from Mr. Hayden to prove the conditions on the property if necessary, if the court would like to go that direction. But ultimately, we would ask for the relief, as I've just noted, and we'd be prepared to submit an order under the 7-day rule that would reflect that request. Happy to answer any questions that Your Honor may have.
All right, thank you. Mr. Bryan, we've been talking legalese, and Mr. Worthington, you got a ticket. Do you have some hearing difficulties?
A little bit.
Why don't we get him one of the assistance units? Yes?
I get paid tomorrow and I just looked up on my, actually after this court hearing is over, I was gonna give them a call because they opened at the same time as the courtroom.
All right, so you're connected to this case also?
Yeah.
What's your name?
Claudia Thompson. Claudia with a Y Thompson. I have the storage unit number saved and everything, that way I can call them. as soon as-
All right, we'll get to that. Thank you. Can you hear now, Mr. Bryan?
Yes.
All right, good. These were an upgrade we got with our recent JAVS upgrade, and they're very helpful for people, so I'm glad that we've got them to use. All right, you got a ticket. This property is in deplorable shape. And generally, they work on this for months or more before they finally cite it. So last December, you got cited with this zoning violation. A hearing was set regarding that, an informal hearing, and you didn't show up for the hearing. So the township asked for what's called a compliance order. And I issued that last June as to you and to Miss Merriman. The compliance order, and I could read it line by line, but essentially it directs that this property shall be cleaned up. Now, you were found responsible in February. They asked for the compliance order in June. Mr. Cunningham referred to two words you may not know: equitable authority and abatement. Equitable authority gives, in certain circumstances, the district court the authority to order that things be done. Essentially, that the township come in and clean this up and give you the bill. That's what abatement is. They would clean it up. So I issued that order. I gave you 30 days from June 2nd to bring the property into compliance with the township and state zoning requirements, remove all unpermitted recreational vehicles from the property, no longer permit people to live in these units, and get all the junk off the property. Apparently that hasn't been accomplished. So the plaintiff has asked for this hearing. So, Mr. Bryan, I'm gonna ask you if you'd raise your right hand. Mr. Hayden, would you raise yours? And Mr. Worthington, raise yours as well. Do you all swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes. Yes.
All right, Mr. Bryan, as I indicated, Patterson Road has had its share of zoning violations up and down it, but this one appears to be particularly egregious. The other thing that concerns the court is when we have people living in these shanty things. On a couple of occasions, someone has died when they caught fire, and people were killed. There are a number of pictures which accompany the original ticket, which were taken back in 2024. The new case shows photographs that were taken by Mr. Hayden on December 3rd of 2025. Is that correct, Mr. Hayden?
Yes.
So you just went out the other day. I'll let you testify from there. So let's see if I can screen share these pictures. All right, we have on the screen some pictures, original and then more recent. So what are we seeing here in the first photograph? It says it was taken on December 9th of 2024.
That is a picture taken from the road showing the campers in the back. And you can see some of the junk over to the right side of the photo there.
You can see the tops of the camper over that makeshift fence.
Yes, there's one there, and then there's one to the right of that bush or tree or whatever it is. That is more of a close-up of the campers and the drive going back to them. There's junk off to the left there.
Now, is this a residence, the dwelling to the left?
Correct.
Does
The house
somebody,
is up front, and there's two campers, at least two campers in the back.
all right, does somebody live in the house?
Yes, I believe that's where James and Connie live.
Okay.
That's just showing the fence and the items on the left there, and then the drive going back to it.
Well, it was a lot different last December 9th than it will be this year, I think. It's still green there. Now, you show here, they've been driving on the neighbor's property. So this shows this poles with these ribbons on it is where the property line is.
That's my understanding. I don't know for sure.
This
That's
looks like
just the citation posted up front.
that fence was new once.
That's just some items that were piled in front of the house.
So in addition to the back, there's a bunch of stuff in the front.
There was, yes.
As I said, these aren't even the worst of them. Now we'll go to the new set of pictures. All right, this is the set of pictures that you took just this week. Is that correct?
Yes.
All right, now, first of all, I guess we should establish, I sort of jumped Mr. Cunningham's claim here and just took over, but do you swear that these pictures are true and accurate representations of what you saw both in December of 2024 and recently here in December of 2025?
Yes, I do.
All right, so you went out just within the last few days and took these pictures.
Yes.
All right, what are we seeing here in this first picture?
There are some tires piled up, lawnmowers. Some of them were just parts. There's vehicles there that have been sitting for quite some time, and other items just that's coming down the lane. Walked down it because it was not navigable by vehicle. Some more of the items off to the left there, tires and other stuff. And then there's one of the campers behind the pickup truck. That is items that are piled up and accumulated there behind the house. There's some type of fence. I don't know if it's for dogs or whatever, but there's again, lawnmowers and some other things that are behind it. That's one of the campers that's being used for storage and or being lived in. And then there's some pallets along the fence there.
So you couldn't tell whether someone's actually residing in there?
In a later picture, there is a porch light on that, on one of them. That's from the back side of that camper, showing there's a generator that was being used in the past, but it's now, it appears that they've run a cord up to the house, and that's shown in a later picture. And some more of the items, tires. That's just a close-up of the items that were piled there, accumulated in the back. That is another area of tires and items accumulated over on the back side of the property. There's two campers there that are shown. One of them, the one on the left, you can kind of see that the porch light is on. Between the two campers, it's shown more clear in another picture, but that's just another angle of the items in the campers. Neither one appeared to be licensed. And then that's a close-up showing the light on. Another angle of the backyard that's next to the campers. I believe the trailer had a plate on it, but the other items would be violations from the vehicle in the background.
This truck back here that we're seeing that's covered with snow, that's currently not plated?
To my knowledge, it's not plated, yes. I did not walk that far up on the property. That's just the driveway they're using that's in the backyard. I could not clearly see if that one had a valid plate on it because it's covered with snow. That's just another shot of the items that are up behind the house.
There's a lot of unoperable lawnmowers around there.
That is apparently a couple of couches and chairs that are sitting in the front yard, front of the house.
Well, most people do that. So that's the condition of the property in the last few days.
Yes, as of yesterday.
All right, I'm gonna go back to some of the original photographs.
Your Honor, there was also photographs that we submitted, and I have physical copies here that were taken in September of 2025, and those ones don't have all the snow, so they're a bit cleaner.
Yeah, I'm gonna go back to those where you can see.
When I wrote the citation, I took everything from the roadway because I felt I had enough to get the citation issued. The compliance order allowed me to go on the property for inspection, so I took a deputy with me on September 4th, and that's the pictures that he's referring to.
Those were exhibit 1 at the informal hearing. And they accompanied the order in June. So we can perhaps get a better view of things without snow over everything. But essentially, exhibit 2. This would be what the property appeared. Oh, I don't have this in here yet. Now, let me stop the screen share. Restart the screen share. All right, is this what the property appeared to look like in September of 2025?
Yes, September 4th.
Which was after the compliance order was issued in June of 25.
Correct. That's when I sent the photos to the attorney to request a show cause.
All right, what are we seeing here?
That is a vehicle that is parked in the back. I do not know if it was licensed or not, but there's also some other items and stuff piled up there to the left. But I believe that, I don't remember if that vehicle was still there yesterday.
All right, here's a better unsnowed view of the trailers. What are we seeing here?
That is the the two campers, one of them, is being lived in, and I believe I was told by one of the, Mr. James, that the other one they were just using for storage, but I did not go in either camper to verify that.
There are two actual gas power generators in the forefront of that picture.
Yes,
Okay.
and several gas cans.
There's a fire hazard. What is this tent structure off to the right?
That's one of those park garages, I call them, where you just put them over the vehicles, or whatever, you can store stuff under them. It's a temporary solution.
And we have a guitar amplifier.
Yeah, there's an old filing cabinet, which was still there yesterday.
Here we got just, I'm not even sure what I'm looking at. What is this?
That is, again, there's the trailer on the right, the car trailer. The other items there, it's buckets. They're full of, I don't know what. And then there's also an accumulation there of the items, just general garbage, and as I refer to them in the ticket, as nuisance items that just don't belong to the backyard.
What is this? A freezer that's on its side?
It appears it could be. In the photo I have here, it's tied shut. You can kind of see the cord there in the middle. I don't know, it's some kind of a container. Maybe it looks blue in my photo here, so it might be just some sort of a, I don't know honestly what it is.
It's my box. It's on his trailer now.
Okay. What is this? Some other shots of the dysfunctional
Yes.
trailers?
Yep. And then another shot of the propane tank and some other things that are sitting there.
There's a dog there. He looks like he's interested.
Yes. That's just a little closer towards the house so that you can see both trailers and the items that are piled in front of the trailer, the rounded trailer there.
This looks like something from the Dust Bowl era from Grapes of Wrath.
Several tires and buckets, and there's containers. There are tools there. Look for maybe working on a vehicle, which would be in themselves okay, but the other items that are accumulated around it would not be.
There are actually two dogs, it looks like.
This is just a close-up of the generators and the cords showing them that they are running to the campers on that day. They were not running when I was there, but I'm not sure if anybody was in them at the time. But yesterday, they obviously were not running, and there is a cord running to the house, which I failed to point out when you had those pictures up. And then again, just the gas cans and items around the back of the camper, the generators.
All right, so that's photographs from last December.
September 4th.
Last September and this December. So I've got to admit all the photographs from all three sessions for evidence in this hearing. All right, I'll stop the live share. We'll go back to our screen. Mr. Bryan, who lives in the house?
Me and Connie.
And who lives in the back?
It's Connie's son and his girlfriend.
Always I shouldn't be any more surprised at how people can live and saddened. But I see this all the time, every month, just accumulated junk. This is several issues. There's sanitation issues, there's fire safety issues, there's electrical issues, there's all this other stuff. So you got a ticket, Mr. Bryant, last December. They had a show cause hearing, or they had a hearing in February that you didn't show up for. You got served with the compliance order in June, which apparently very little's been done to clean it up. And then they were out there again in September to take other pictures. So their patience is wearing thin. What's your position here?
Well, in 2023, or June of 23, I went from Judge Hostetler, gave me 2 PPOs I had put against her son and his girlfriend, and the sheriff come out and told me to stay up there at the house, that the county owned half the property, and she gave him permission to be out there. And
who's Judge Hostetler?
Our brother from here.
Well, let me see what you got. You had some stuff in your pocket. Do you have the PPOs?
Yeah, okay.
All right. Claudia Thompson. You got a PPO against Claudia Thompson, issued by Judge Stutzman in 2023. And it's often difficult to do a PPO when the people are on the same property. This was by Judge Stutzman. And then you have a PPO against Charles Worthington. These are expired. They're not currently valid.
That's just so I show that, you know, they.
All right, so you got a PPO against them, correct? All right, so is all this junk in the back belong to Charles Worthington? So you got a PPO against them. They live in the back. Are you and Connie married?
No.
Do you jointly own the property?
Yes.
All right, so she has a joint own tenancy with you.
I was a co-signer for the property, so it's I'm considered third party. You got Connie and then the mortgage company and then me.
All right. So, all right. Do they pay any rent?
No.
All right, Mr. Worthington, why don't you come up to the podium? Come right up here if you would, when you're under oath. Good morning, sir. Are you Charles Worthington?
Yes.
The township is taking expensive legal action to get all your stuff off this lot. What's your position?
We just got back to, or my fiance got back to work. We're trying to get stuff caught up and get the storage unit so we can get the stuff out of there. And I've been cleaning it up.
All right, well, it doesn't have to happen as soon as tomorrow, but what are you gonna do with these trailers?
Getting storage units for them.
This storage unit has outside storage and facilities that can store.
All right. All right, thank you. You can have a seat. All right, so Mr. Worthington is apparently the occupant of this site, along with Miss Thompson. I can't believe someone would live there, but they apparently do. And they are willing to begin removing their property. They don't own the property. You and Miss Merriman do, and she's not here, so she's gonna get defaulted. But the person that's gonna get the bill for this is you and Connie Merriman. And the bill is gonna be tens of thousands of dollars. Unless they remove the property from there. They're gonna have to hire a company. They're gonna come in there. They're gonna load up all that stuff into dumpsters and take it to the dump. They're going to hire a company to tow off everything there that is not licensed and take it to the dump. And they're gonna give you a great big bill and apply it as a lien on your property. The township has been very patient. They worked for a long time before December of 24. They had a hearing in February of 24. We had a compliance order in February of 25, compliance order in June of 25. And you guys have responded to this by essentially ignoring it. One problem we always run into at this time of year, Mr. Cunningham, is we're covered with snow. The ground isn't quite frozen. It's going to be muddy, difficult to get that stuff out of there. So that's always problematic. And it's always to the township's benefit if the parties get the stuff out of there themselves, rather than having you hire a company to come in and do it. How much time are you willing to give them to remove the property?
Your Honor, I think practically speaking, it's going to be until spring before the township could get a contractor to go out there. So I think the court's well aware at this point, it's been a long time. And so we would ask to be authorized to remove the property immediately. But I think for practical purposes, it would be probably at least a month or two, maybe March, I would say is a reasonable timeline. Whatever the court would like to do in that regard. But we would ask to be authorized at least immediately, given that it's been so long since the compliance order came out.
And that's what I'm, and as I said, we run into this every year in December and January, and they've neglected it. But one problem is someone's living in there, and that's immediately going to be prohibited. They're going to have till March 30th to remove the property, or the township is authorized to remove the property and bring the property into compliance.
Your Honor.
Yes.
They have done quite a bit of getting stuff out of there. And also, I believe we got the property and house sold, and the closing on that is supposed to be first part of January.
Okay. Who's the purchaser?
I don't have my phone with me, but they're out of Florida. One of those, that buy.
Will buy your house. Okay. Well, maybe that's a way to resolve this. In the meantime, you can't live in a trailer parked out behind somebody's house with a cord hooked up to the house. Someone's gonna die out there.
I'm currently working with neighborhood Inc. because they had to fire everybody that was there. They apparently weren't doing their jobs. They got all the people from there, and that's right here in Centerville.
Okay, well, I'm glad they're back in Centerville. I had not heard. Maybe I'll contact them. All right, let Mr. Cunningham, that complicates things. Certainly, this often fixes it. A bank repossesses the property and they clean it up. Someone purchases it, maybe a neighbor purchases it because they're tired of looking at it. They clean it up. I'm going to give in the order the plaintiffs have the right to enforcement. Defendants and their successors shall have until March 30th, 2026 to clean this property up. So if someone buys this property from you in January, the township won't take any action until March 30th. But you got stuff in the front yard, stuff in the backyard. The occupants of the trailer have 10 days to vacate or they will be in contempt. In which case I would do an order ordering the sheriff to come evict them from that property. That's dangerous. It's not sanitary. It is an electrical hazard and it's dangerous. And you can't do it anyway. So you have 10 days to get a place to go or take that. Is it a motorhome or a trailer? It has an engine in it? Trailer, okay. You don't have to move it within 10 days, but you have to be out of it within 10 days or I'm going to find you in contempt. Mr. Cunningham or Mr. Garuda, anything else you wish to add to the order?
Your Honor, if we could just clarify the issue of attorney's fees.
Yes.
In the past, when we've done this, we've just submitted a bill of costs with both our fees and Mike's fees along with that 7-day order.
The statute does allow for that. There is going to be an order for money for their attorney fees. The township is spending thousands of dollars for this enforcement. And this started out small and grew into what it is. Why people store junk tires? Because it costs money to get rid of them. Twice a year, you can dispose of them at the county disposal day for $2 a tire, but there's probably 100 or more tires on there. All kinds of other stuff. Some of it has value, the generators or boats and some of it's just plain junk that needs to go to the dump, and some of it may be scrap that has some monetary value. But I'm sure that whoever's buying this property doesn't wish to buy it to have a junk heap on it. I think they're going to turn it into a house like it once was. And as I said, they're attempting to clean up all of Patterson Lane and all of Lockport Township, one parcel at a time. This would be a default as to Miss Merriman because she did not appear. But it's the same order that would apply to Mr. Bryan. So Mr. Bryan, your plan is you and Connie plan to move out of the house sometime before January.
That's the idea.
And then the new purchaser will have it. And in the meantime, Mr. Worthington and Ms. Thompson are going to try to clean the back up. That personal protection order is no longer in effect.
Right.
But so is it
No, I just,
but so you stay away from each other? You stay in the house and they stay in the back?
yeah, basically.
Well, it's your property and Connie's, and you can't let people do it. Your neighbors are complaining. The township's complaining. People complain to the township. Like, how could, in fact, as I'm looking at it, I'm thought, how could this exist? How it took this long? But I often feel that way when we get into these situations. They don't happen overnight. All right, do you have any questions?
No.
All right, they're gonna do an order after this hearing where I find that you are violated my compliance order by doing nothing. Miss Merriman isn't here. She lied to the court when she said the roads were bad and she was late. She just wasn't coming. So her son has come, but he's a source of much of the problem. So it's good that he's here.
She is sick.
Okay, well, she didn't tell me that. She told me she was on the way here.
I'm not my fault. I said that her son was representing I let them know up there that she was not feeling good.
Okay, maybe I misunderstood. At any rate, you guys got work to do. Anything you want to get out of there that you don't want destroyed, junked, you need to get out of there. So if you've got a storage space and you're gonna pull all this stuff out of there, you got sooner rather than later, because the property's gonna change hands in January. There's also gonna be an assessed cost for attorney fees and the inspection and enforcement fees. You won't like that much, but it will be attached to the order with what's called a bill of costs. And you and Connie are jointly responsible for that. Maybe you can use the proceeds of the sale of the house to pay those fees.
Your Honor, if I could just clarify the order, then if they do go unpaid, either the attorney's fees or the cleanup costs, if we get to that point, would we be authorized to impose them as a lien? I know the statute
Correct.
provides for
That's
that, but
correct.
just to make sure it's clear. Thank you.
All right, anything further? All right, Mr. Bryan, do you know where you're moving to?
No, not right offhand. Say my brother's got a place in Florida. I thought about.
Yeah, I didn't know if you were gonna move out of state, if you're gonna stay here in Michigan.
I have no idea right now.
Well, there's not a lot of time between now and then.
Well, till I get some cash from the house there, right? And my understanding is me and Connie will be splitting up. So she'll take her half of the money and.
All right, well, maybe that's for the best. They'll get the junk off the property, someone will buy it, somebody will turn it into a habitable house. Township will be happy and you guys can start fresh somewhere else. All right, this record is completed. I'll await the order under the 7-day rule. And you guys are all good to go. Mr. Worthington, you got your work cut out for you, but let's hope the weather breaks a little bit. All right, thank you.
Thank you, Your Honor.
What an absolute mess, literally and figuratively. Lindsay kind of summed it up in the chat saying, you know, what's worse, the mess, the situation this guy's in overall, like the overall situation, like it's, I don't know how to answer that. It's a mess. That's all we can do. You know, we saw Hoarder Man in Judge McNally's court, the ongoing saga of Hoarder Man, which will continue in January. But this is like Hoarder family. And so I know we're also having there's these little periods of static on the mic here. I'm using a brand new setup this morning to host the Courtroom Files Live, filling in for Dan Soul. So I haven't completely configured the hardware. So my apologies for that. Grandma TCF, thank you for the $20 super. Really do appreciate that. Thank you so much for helping out. All right. That was quite a hearing. All right, we got a number of places we can go, of course. Let's see. Let's go and see what's happening with Judge Simpson. We'll keep it in Michigan.
So the case is.
Now let's see what's going on with Judge Simpson this morning.
Does exist, given the waivers the court will consent to. Court does call the case of the people, state of Michigan versus Devontae Miley.
Devon.
Ash Phelps for the people.
Devon.
Assistant Public Defender Jay Bellinger on behalf of Mr. Miley. I knew what you meant, Your Honor. Mr. Miley, can you please state your name for the record?
And Devin Skyler Miley.
Thank you, sir.
And Your Honor, I have executed a waiver form on my client's behalf. I did sign his name to that. We are prepared to do that today.
And he's waiving on all four cases.
All four cases are accounted for.
All right. Sir, you're waiving your right to a preliminary examination, is that correct?
Yes, Your Honor.
Okay, and you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you'll not have that hearing on any of these matters and you'll proceed to circuit court for further proceedings.
Yes, Your Honor.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on all, I think they're all felonies, correct?
That's correct.
on all 1, 2, 3, 6, 7 felons.
Your Honor, we acknowledge receipt of information, wait formal reading, stand mute at this time.
Defendant having waived formal reading, standing mute to all charges, court will enter not guilty plea. Pretrial in this matter will be set for
December 23rd at 1:30 with Judge Cunningham.
December 23rd, 2025, 1:30 before Judge Cunningham.
Thank you, Your Honor.
Bond will continue.
I know.
Go get it. Court does call the case, People versus Lloyd Sanders.
Ashley Feltus for the people.
Your Honor, Alexis Plumai appearing with and on behalf of Mr. Sanders, who is present via Zoom from Wayne County. Mr. Sanders, could you say your full name for the record?
Lloyd Bernard Sanders, Jr.
Thank you.
I have before me a plea form that indicates that the defendant would be pleading guilty to the charge of attempted resisting and obstructing a police officer to 1-year offense. Upon his successful plea to that charge, count 1 would be dismissed. That is the court's full understanding of the.
Yes, Your Honor.
Mr. Sanders, can you raise your right hand, please?
Yes, sir.
Do you solemnly swear or affirm testimony you're about to give will be the whole truth and nothing but the truth, so help you God?
Yes, sir.
All right. State your name again for the record, please.
Lloyd Bernard Sanders, Jr.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor, punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that?
Yes, sir.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court.
Yes, sir.
All right. Do you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind?
Yes, sir.
You signed an advice of rights form after going through that with your attorney?
Yes, sir.
You have any questions regarding any of those rights?
No, Your Honor.
You understand that you're waiving or giving up those rights, particularly the rights contained in paragraph 5, which are your trial rights?
Yes, sir.
You understand you're giving up your right to appeal outright?
Yes, Your Honor.
Are you on probation or parole?
Yes.
Were you on probation or parole at the time of this offense?
Yes, sir.
All right. Sir, I would have to advise you that your pleading in this case, or pleading guilty in this case, could become a violation of your probation. You understand that, sir?
Yes, sir.
And you understand that as such, if it is considered a violation, the other court could sentence you to the maximum allowable under those other charges.
Yes, sir.
Understanding that, you still wish to plead guilty to this charge?
Yes, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Has anybody threatened you or coerced you in any way?
No, sir.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes, Your Honor.
And because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
On the date of March 7, 2025, at the location of 1700 South Industrial Highway, City of Ann Arbor, Washtenaw County, State of Michigan, did you come into contact with police officers from the Ann Arbor Police Department?
Yes, sir.
What happened?
He stopped me on the street, called me by name, and I took off running.
All right. When he called you by name, what do you mean? Was he asking to speak with you?
Yeah, he said, Lloyd, you're under arrest, you got a warrant.
Okay, so you knew that you had a warrant and he was going to take you into custody?
Yes, sir.
And you took off running?
Yes, sir.
How'd that work for you?
Not good.
Never mind. You don't have to, I don't need that for the plate. All right. Sir, I do have to advise you that if I accept your plea, between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules,
You would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. Do you understand that, sir?
Yes, Your Honor.
Is counsel aware of any other promises, threats, or other inducements which had led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court rule?
People are satisfied.
Defense is also satisfied.
Court will accept the defendant's plea of guilty to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be December 19th, 2025, 8:30 before Judge Perry. Bond in this case will continue. Thank you, Mr. Sanders.
Thank you. Have a good day.
You do the same. Court does call the case of the people versus Jacob Halfacre.
The water assistant prosecutor.
Good morning, Your Honor. Michael Vincent on behalf of James Halfacre.
Your name, sir?
Jacob Halfacre.
All right. And you are requesting a forensic evaluation for competence?
No, we have one. It's been we got the report, but I'm asking for a forensic evaluation of criminal responsibility.
Right, I would order that, but that would not be dealt with at this level. The criminal responsibility we dealt with at the circuit court level should it get there, but I mean, I'll order it, but
I would appreciate that.
But we dealt with the competency issue, haven't we?
Yes, there's a report. I would like a hearing on that, Your Honor.
When was the report?
I have a report dated November 21st.
I think the last one I had was November 13th. It should be the same report, though.
Looking with dated November 21st, this one opines that he is no longer incompetent to stand trial.
That's why I want to have a hearing.
I don't have that. For whatever the reason, I do not have the November report, but if somebody could make sure to send a copy to my office, because I can't even make a finding at this point.
I'll forward that right now, Your Honor.
What? Oh, we have it, Mr. And so you want a hearing on the?
Yes.
Restoring competency. All right, I'll set a competency hearing, contested competency hearing. On that report, I will set that. When's my next?
Where are you at?
December 23rd. Yeah. Yeah. I'll just do it.
That's everything.
Yeah. I'll set that for December 23rd, 2025 at noon. That's before me. For a contested competency hearing. I will sign the referral for criminal responsibility, but I frankly won't hold up the district court proceedings because of that.
Yes, I understand.
Because we don't deal with that. All right. Okay. Thank you. On continued. Thank you. This is our, we need to make a copy of the same. Here. Court does call the case People versus Azzi and Braswell.
Andrew Children, friend on behalf of people, Your Honor.
Is that you, buddy? What's a jerk? Did you say hi to you? Did you? Did you? He won't even talk to me. I'm feeling. Yes, sir, go ahead. I'm sorry. We were just having a moment.
I know. Keep going. I'm good. Your Honor, good morning. Chris Easthope appearing on behalf of Adrian Braswell. Mr. Braswell, would you unmute and state your name for the record?
Ruh-roh. No.
Uh-oh.
He's not here.
He's not on? Can you pass on a couple others?
Labeled and my staff is telling me he hasn't checked in. I only have 157 to go. You want me to wait?
No, I have two others. You can go to those.
So we want me to do is this one?
Just put it two back.
So, in other words, you don't want me to issue a bench warrant?
No, no.
Oh, okay. No, I was just waiting for you to text.
I just texted him.
You're okay.
Don't do the bench warrant just
Then we'll
yet.
wait. I'll do
All right.
Glad you haven't ordered it then. Court calls the cases of the people versus Thomas Pratt.
Attorney sitting in for AK Kennedy.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Pratt. Mr. Pratt, will you state your name for the record?
Thomas Pratt. All right. In this case, we received a communication November 20th from Health and Human Services indicating, or at least opining, that he's incompetent to stand trial, not likely to competence.
And not likely to?
Yes, not likely. What would you like me to do?
Your Honor, based on that, I would prepare an order to that effect if the court would be willing to sign that. I'll make sure we have that.
All right. And then what are we?
In our file.
You're going to prepare an order to that effect, and then somebody's got to do something with the case. So why don't, go ahead. It would, all right, once that order is signed.
And that is for all three files, correct?
Yes, it would be. So why don't let me just put it over 2 weeks.
Okay.
And then that way the order could get in and then we can accomplish the dismissal.
Okay.
So competency hearing review will be, okay. Put it over to December 18th, so we can get the paperwork and everything together. 2025, 9 a.m. Bond continue. Thank you.
He can hear you.
Court calls case of the people versus Walter Peterson.
Cash calls for the people.
Your Honor, Alexis Plumai appearing with and on behalf of Mr. Peterson. Oh, he's on Zoom.
Peterson, can you state your name, please, sir?
Walter Peterson.
Thank you.
And Your Honor, we are just requesting a brief adjournment. There's just some surveillance video that we still don't have.
I'm sorry,
There's some media discovery.
that you don't have?
Yes, yeah.
All right. And would the people be able to get that to you by the 18th?
I believe so, Your Honor.
I'm sorry, Your Honor. What was that? I apologize.
There's media discovery, I guess, that's missing.
Yes, that's my understanding. They're looking for some additional videos.
All right, and that can be accomplished by the 18th or prior to.
I think we should, let's try for that date since you think. Thank you so much, Your Honor.
Probable cause conference, December 18th, 2025. 9 a.m. Bond continued.
Thank you.
Thank you. Court calls case People versus Jonathan Coleman.
Alex, on behalf of the people.
Seventh Street, still, there it is.
Ellie, did you put your appearance on already? Chrissy,
Hours ago. No, go ahead.
Mr. Braswell signing on, by the way. That's why I just got off the phone. Your Honor, Chris Eastup appearing on behalf of Jonathan Coleman. Mr. Coleman, just state your name for the record.
Jonathan Coleman, Your Honor.
Thank you. Your Honor, we're going to set this for a preliminary exam. I believe Ms. Senda said, did you say the 30th or the 23rd? I'm sorry,
Yeah, we're looking for the 30th potentially.
for an exam date.
So we'll be out.
If that would be allowed, Your Honor.
You're pushing it, Easter.
I know.
All right, all right. Is all discovery complete?
Yes. From the defense.
And would the people have their witnesses, the 30th, like way at the end of the month?
We'll do our best, Jeremy.
All right. Preliminary examination in person will be set December 30th, 2025, 9 a.m.
Judge Washington.
before Judge Washington. Bond will continue. Thank you. Court calls the case People versus Benjamin Spike.
No, he did not. He.
Judge, Torshel Feaster on behalf of my client, what's your name? Benjamin. Yes, Mr. Spike. On behalf of Mr. Spike, please take your name for the record, sir.
Benjamin Spike.
All right.
Thank you, Judge. I did meet with Mr. Spike yesterday and speak to him in custody. I also reached out to Mr. Childers. I believe we're still trying to get this matter resolved. I'd be asking for a brief adjournment.
Not objection. Probable cause conference will be adjourned December 18th, 2025, 9 a.m.
Thank you.
Bond continued. Court calls case People versus Harold Couch.
Morning, Your Honor. Michael Vincent on behalf of Mr. Couch. State your name.
Harold Couch Jr.
Thank you.
You're seeking an adjournment?
Yes, Your Honor.
Well, you're asking about DNA testing. I don't know how fast that's gonna.
Your Honor, the testing is supposed to already be underway. We just haven't gotten the results back yet. ABA Kennedy did send an email asking on November 18th for an update. We haven't heard back from everything.
All right, so looking for an update by the 18th?
No, I'm sorry. We sent the email on November 18th, so
Okay.
I'm not sure exactly
Where we are.
start with.
He's out of custody, so let's do this. Will the 23rd work for Mr. Vincent? It will, and then he can get on a sleigh, and drop all the toys.
That's the next day, Your Honor.
What, that's the next day?
Next day.
Oh, okay, all right. Probable cause conference will be adjourned December 23rd, 2025. That's 9 a.m. All right. Thank you. Bond continue.
All right, Judge Simpson in very good spirits, and we love to see that. It's the Courtroom Files Live. It is Thursday. I'm Michael GROFF, sitting in for Dan Soul. Let's see. We've got, we still have a number of places to go here. Some of the courts have quieted down a bit. Middleton is in recess right now. That was quite a long hearing we had with him earlier today, but I say, let's see, why don't we head to Texas. Let's check in on Judge Stevens and see what's going on there.
When you're multitasking, 24 CR 2385 is now called the State of Texas versus Leon Goodman III, who's present with his attorney and the state's attorney. Mr. Samuel, does the defendant waive a formal reading of this indictment and the arraignment? Can we proceed in a summary fashion?
Yes, Your Honor.
In summary, this indictment alleges that on or about July 6th, 2024, in Jefferson County, Texas, you committed the third-degree felony of injury to a child younger than 15 years of age. You understand what you're charged with here?
Yes, sir.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty and placed on deferred or unadjudicated probation, which can be up to 10 years in length, fine $500. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
He's got to sign something here. That last. At the bottom.
Cheers.
It's hard to write like that. It's in things.
Again, sir, how do you plead to this third-degree felony charge, guilty or not guilty? I'm sorry.
Yes.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty of what this alleges?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
And without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You are totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes, sir.
Correct. States Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
Yes, sir.
I am going to follow this agreement. Yeah, go ahead.
Your Honor, this is a bit unusual, but this is a case that I didn't get much sleep last night about this. It kind of concerns me. One is about the way the operation of the patch has been. It shows he has consistently had dirty patch.
What was
And
it saying?
He's arguing about the dirt patch. Where did we?
Oh, these things?
Yeah, we hadn't talked about that since we're doing the probation yet, so we'll see.
Well, it's consistent. It's showing up positive for phencyclidine.
Right.
Which is about as bad a drug as you can get.
Right.
Well,
here's
okay, we're gonna, unless you can prove otherwise, I'm going to trust the science of the methodology that we've been using.
I understand, and I just wanted to bring that to the attention because this young man, I've been working with for now about 9 months. And I was even, when I received these tests, it perplexed me. But I felt from my experience with him and what he's trying to do, it kind of concerned me because this is a guy that I've seen use a scooter. He's working at McDonald's, 19, and he's used a scooter to get to work. And he's finally purchased a car. He's working.
What does that have to do with his?
It's his character.
Or
hold
on. But he struck a 7-year-old child. Is that also odd of his character?
Yes, it is.
Okay, I know, but he admitted to it. He admitted to it. Okay, so he's capable of doing bad things.
But the light that these things have shed on him impacts the way people perceive him. And that's why I really had a problem with the case. Because
we never had problems with historically, we never had issues on challenges. We can always have it, I guess, but these tests are never challenged. And when they are, I guess we can deal with them. but there has never been anything that's proven to me in 20 years
Well, we hope we don't have any other
that
problems.
these are false.
Yeah.
These would be false because we're going to continue to use these as the industry standard.
And as I told him, this is the first time I've had concerns about it. So we're okay, but there are glitches at times. And I don't know what it is. I don't know if it's something in his, I don't know. But this really bothered me. And
well, it's all that I need to
and that's what had me so concerned.
Basis, because all I need is preponderance of the evidence, and I'm going to trust the medical standard unless you're able to convince me otherwise. But this is the industry standard. And
what we're going to do, we're going to get hair follicles also on his own. So I'm just concerned about this being
those hair follicles. Okay, here's another one. Those hair follicles, nah. On his own, no. You want to do a hair follicle? We'll come in and we'll get it done through, because you can use a hair follicle, put a hair follicle aside and then throw it into the to the test.
Well, I just want to make sure.
And he's controlling the test.
Okay.
But this is really weird. Well, and let me ask you, do you have an explanation for this? Is there why would you be testing positive for phencyclidine? Any reason? Well, you're going to have to come up with a good reason, because I'm going to presume these tests to be accurate if they are properly administered. The methodology of administering, that's always subject to question, and that's why it has to be proven it was done correctly. But the science of it and the acceptance in by government officials and by lab testing, these folks stand by the accuracy of their tests. So these are 4 or 5 positive tests of phencyclidine, which is as bad a drug as you can get. And they won't be tolerated on the court's watch. I've never had these many successive tests. So if you're going to have to figure it out too. If there's something being done that's inaccurately causing these to show you are positive for phencyclidine, you better have a good reason.
Do some research on it. Okay.
You better have a good reason.
Okay.
Because we're going to tend to agree with the test unless it can be proven that it was not administered properly. But the packaging, the way it is controlled, and the way it is administered in the way it is supposed to be done to pass all government requirements, there's not a likelihood that these are false when you have this many. Something is happening wrong here. Okay. But you're on probation now, and this is probation for a 3rd-degree felony. 10 years in prison or what you're going to be facing. Okay. So there is sufficient findings. State's Exhibit 1 is admitted here. You have pleaded guilty to this indictment voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm not going to do that. I'm going to place you on deferred or unadjudicated probation. I generally do 10 years, and then I reward people. You can be released in a third of this, which is 3 1/3 years for good behavior. And I actually do it numerous times each week for people. We move them off when we've got it done. So that's what you're looking at, is you can be released 3 1/3 years for doing well. You're going to do that?
Yes, sir.
Okay. Even though I could find you guilty, I'm not going to. I'm going to defer or postpone any finding of guilt so long as you follow the terms and conditions of probation that the probation office is preparing. And they go over those with you. And most of those requirements are what I have to do. The same requirements I do, and I'm not on probation. So these are all done to help you be the best you can be.
Yes, sir.
Okay. And we also are very prideful on our great success rate of probationers. We don't want you in that 7 or 8% that are failing. We have a 92 to 93% success rate, which is way higher than the national average of probation office.
Yes.
Because we don't like failure. We want you to succeed, but you've got to do your part. We're not going to drag you. We're going to help you, but you've got to walk on your own 2 legs across the finish line successfully. You're able to do it, right? This phencyclidine stuff, I don't know where that's coming from, but first of all, that's straight from hell. And I mean, there's very little usage for it, and it's in a very limited area, and it has no purpose, good, decent purpose, being used without authority of a physician. And it would, I don't even know why it would be used. I think it's used in some limited, very limited purposes, but phencyclidine is the devil itself. And it does not help you be the best person you can be, or anyone else who flirts with it. So be very careful.
This concerns me.
That's, well, I don't know how that happens. If it's, you know, we don't know. And but we also know he's a smart guy. I'm a smart guy. We've done this long enough. This is unusual.
Yes, sir.
When we see this happening, there's generally only one reason. You're not telling us the truth. You know it. Then you're not telling us the truth. That's generally what the answer is. Now, there can be an exception, but it's really hard to imagine how you can have a consistent positive reading if you're not around it. And that you're around it. And not knowing that you're around it. I mean, I guess somebody could inadvertently be slipping that on you without you being aware of it, but I don't know how that can happen. And that I've never heard of such a thing. And I don't even want to suggest it to the outside world for people to come up with ideas. But we do this enough to know there's a consistency in the method that we practice up here. And when we see something unusual, it gets our attention because an anomaly is generally not a good act by the defendant. It's generally their mistake, not ours or the test or the machine. So be careful. And phencyclidine is a felony. That's a felony offense. It's a very serious felony because it's such a dangerous thing. Okay. So we got you here. You've got a second chance. Make the most of it. What are you doing for your occupation? For work?
I'm working at McDonald's.
Okay. What do you do there?
I'm a crew leader.
Crew leader?
Yes, sir.
Are you good at it?
Yes, sir.
All right. Those McNuggets. What's the secret ingredient? No, I don't want you to tell me. I don't want you to tell me. There's a good corporation. Do you have managerial? Are you trying to get into the management position?
For the start of my career.
Okay, is that what you want to do?
Yes, sir.
Yeah, okay. Well, they're going to be around for a long time, and I hear they are very they award their people who are loyal to them, so they're a good company.
So was there a $500 fine on
There was a $500 fine, among other conditions of probation. There will be conditions of probation which are normal and customary for this type of offense. Is there anything else that's unusual on this one for these facts? Is delivery to a child?
No, Your Honor.
Yes.
This was not his child. This was something totally, it was a weird anomaly.
Yeah.
That's his child in the back.
Okay, but well, you got to be careful about.
He stepped in,
The-
That was the children, yeah, that's what it was.
Well, where was the parents?
The parents, they were nowhere around.
They were nowhere around?
I was the only.
Have you talked to the parents about it?
No, sir, I was supposed to stay, 100 feet away
Well,
from them.
generally, that's their responsibility, but also you can't, you have a humanitarian requirement of helping to prevent injuries to children.
Yes.
But there must be something else behind this that, but anyway, you got deferred, make the most of it and do well in your career. Okay.
Yes, sir.
Stay away from illegal substances. Okay. Anything else? That is all. Please see the probation officer. Thank you.
Those McNuggets. Those McNuggets. Yeah, Judge Stevens channeling his inner Judge Boyd there. All right, let's see. Let's head back up to Michigan. And let's see what's going on with Judge Oakley.
Good morning again, Mr. Gwitt.
Oh, Your Honor, Murray Gutman, on behalf of this defendant, Albert DeWitt, Jr. I don't think he's been arraigned, Judge, has he?
Let me look. No, way formal reading.
Yeah, waive the formal reading of my client's standing.
All right. And what are we doing today?
Great.
Heather, do we have any dates with Van Buren? You already got it? Oh, gotcha. All right. All right, let me put a bond together. We'll get you guys out of here. We got their notices already?
No, I was waiting to see how much you need to win amount for.
I'll do $1,000 check, personal. All right, Mr. Gwitt, your personal bond conditions: number 1, stay out of trouble. Number 2, be in court for your court dates. Number 3, do not purchase, possess, or consume any mood altering substance unless you've got a doctor's prescription. Understand all that? Yes. Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court, amount of $1,000 if you must up on bond? Yes. Any questions? Anything else? We're all set. Have a great day, guys. I signed that. Not realizing I was setting it for trial instead of taking a plea. So, Jamie, the pile to the right, we're waiting for IDC.
I have the names on this top.
Yes.
Yep.
That's the difference. These are no attorneys. These are MIDC.
MC's no counsel, and then it's
Got
at the top.
Got it. Orlando Pierre Fees. Good morning. Hyphenated, Pierre hyphen Phils. Are you going forward today without a court-appointed attorney? Did you understand that while I joked? Are you going forward without an attorney today? Not a trick question. You're standing there alone. Do you want an attorney to represent you? Okay. Then go talk to the attorney. Joshua Taylor. Mr. Taylor, are you going forward today without benefit of a court-appointed attorney? And you've met with the prosecutor on your own. You made a deal. The paperwork tells me you're going to plead guilty to the added charge of allow unlicensed driver to operate a vehicle on October 31, and both the original charges would be dismissed. Is that your deal? You understand your rights and options? And do you understand the possible penalty for the added charge? Well, possible penalties up to 90 days in jail, up to $500 fines plus court costs. Likely penalty is no jail. Understand? Understanding all of this, are you pleading guilty freely and voluntarily today? On that date, were you driving a vehicle at or near the airport? Metro Airport to be specific. And on that date, did you have a valid license? Were you suspended, revoked, or denied? I'll accept your plea and I'll dismiss both the original charges. What's the status of your license now, sir? Good, got it back. Wonderful. All right, and are you working? Who do you work for and how long have you been employed there?
The campus been there for almost 3 years.
Where at? What do they do? It's a who? And it's called what? Oh, I thought you were saying crave canvas, and I'm like, canvas? What's that got to do with dope? All right. Anything else you want me to consider before I sentence you? No magic answer. I'm just giving you a chance to talk. Okay. All right. You're probably about 20 minutes from here, where you live? Yeah, about 20 minutes, maybe a little longer. Yeah. All right, normally I would order work program on this one. I'll give you the option. So it's fines and costs are $500. And I usually order 4 days work program as an alternative to jail because nobody wants to go to jail. So I'll give you the option. You could do 4 days on our work program, which means you pick 4 days, and those days you got to show up here at 8 o'clock in the morning, go out and work with our crew. It usually works out to be like a 5-6 hour day. Or I'll give you a certain number of community service hours you have to complete, which means you got to find some nonprofit charity. You got to work with them. You got to get the documentation and get it back to us. Which option you want to choose? All right. So go downstairs. You're going to pay the $5 today, or you need to talk options? Go downstairs, talk options on payments, have something set up before you leave the building, and schedule your work days. No, you want a community service, right? Got it.
Thank you. Thank you, sir.
Let's do 30. So 30 hours community service. I'll give you until February 1 to complete and document. So if you come to me before February 1 and you need some time to finish, I'll probably say yes. If you need some more time to start, I'm going to say no. So don't put it off too long. Any questions? You're all set. Have a lovely day. Jose Samano. Good morning, council. Your appearance.
We have the defendant, it's not on this present to my right, you can see.
Good morning, sir.
For an arraignment, pre-trial for arraignment purposes, we're standing at way formal meeting.
All right, you've worked out a deal with the prosecutor?
It was in exchange for dismissal of the unblinded public violence. My client was under agency to allow an unlicensed driver.
Good. Have you discussed your rights and options with counsel? Yes. You understand all those rights and the options they present? You understand the possible penalty for the added charge? Understanding all that, are you pleading guilty to that charge freely and voluntarily today? Yes. Did you drive a vehicle on October 20, 2025 at or near Metro Airport while your license was suspended, revoked, or denied? Yes. Counsel satisfied? So am I. I'll dismiss the original charge. What should I know before I sentence?
My client's taking this matter seriously. He has somebody with him today who drove him.
Good.
He's not operating anymore.
How far away from a valid license is he?
Because that.
Okay. Okay.
Probation can judge now, and when he comes to the court, we're dealing with some issues over.
Okay.
We've got some time to get all that.
Get all the ducks in a row. Okay.
Yes, my client is paying fines and costs to circuit court. We would ask that any kind of costs assessed here, that perhaps you could have a month to start.
Yeah, we'll work something out. That's easy. Yeah, it's easy to do that. You working?
Yeah.
Where do you work? How long you been there?
I've been there for 3-4 years.
What do they do at BKJ? Concrete work? Doing any now?
Yeah, we're still doing the last bit of work. Yeah.
Okay. Getting pretty cold for that.
Yeah.
Yeah, all right. Anything else I should consider? All right, sir, I'm gonna find the cost on your file total $550. I'm ordering 4 days on the court work program as an alternative to jail. You want a due date on that money, or you want to set up some kind of payments? What's easier for you? Tell me when. Look at the calendar. Tell me when you can pay it.
First week of January.
So let's do it by the 8th. All right, so go downstairs and you can schedule your work days. Work program is assessed as an alternative to jail. So too many problems on work program, that's not an alternative anymore. Have a good day. You're welcome, counsel. Dylan, is it Humberger? Good morning. Are you going forward today without an attorney? You've met with the prosecutor on your own. Let me see what we got. Would you, Miss Manarino,
Yes, Judge.
good morning.
Morning.
On Barger.
Yes, Judge.
You've got a restitution to be determined. Are you
Yes,
gonna
Judge.
track that down?
I am.
Okay, all right, so if you're okay with it, what I'll do with the file is I'll go ahead and move forward today and just leave that open, so if you come back with a claim, we'll send it out to Mr. Humbarger, and then if he has a question about it, we'll have a hearing.
Okay, perfect.
That make sense?
Yep, that
Okay,
works. Thank you, Judge.
Thank you. All right, I'll explain that. So did you read your rights form? Did you understand your rights and the options they present?
No, sir.
You did not understand your rights?
I understand my rights, just not that.
Okay, well, for example, you have a right to go to trial. If you decide to go to trial, you have a right to go to two different kinds of trial, jury trial or bench trial. That's what I'm talking about. Okay. That's all right. And the charge you're pleading to fail to report, you understand the possible penalty for that? Understanding everything we just talked about, are you pleading guilty to that charge freely and voluntarily today? Did you drive a vehicle in Van Buren Township on September 21? Were you involved in a motor vehicle accident? Did you report that to the police as required? I'll accept your plea to the added charge, dismiss the original two charges. So what we're talking about is restitution. She'll reach out to the other party that was, the other car was all involved, whatever. If they make a claim for restitution, let's say they want you to cover their $500 deductible or whatever, we'll notify you. I'm assuming we've got your good address on Beach Daily. We'll notify you and say, look, the other party's made a claim for $200. You can just say, fine, here's my $200, or you can say, wait a minute, that's way too much money. And then we'll just set up a hearing. Understood? If we don't hear anything back from them, you're not going to hear any more from us.
Yes, sir.
Okay. Are you working?
Yes, sir.
Where do you work?
HPC Alliance Mobile in Nova.
How long you been with the company?
2 months, I'm going on 3 to 13.
New job.
Yes.
All right.
And,
Good to know people.
sir.
Okay. All right. Anything else you want me to consider?
This board has turned my life around for the better for the past 3 years.
What'd we do?
You sent me to youth challenge, sir.
Did I? I don't remember. Man. So 3 years out?
3 years out.
Good for you.
My first involvement with the law since, and I'm just want to say thank you, sir.
Good for you. Thank you. You just made my day. Might have made my week. We'll see how tomorrow goes.
Much appreciated.
Awesome. Awesome. So I got a kid. I just talked to a kid last week. Was it last week? They're changing the challenge, or at least I think it's a new change because it's the first I'm hearing about it. When you went, you had to be 16, right? You can go now if you're not yet 16.
Really?
And what they do is it's like a credit recovery thing. You go to the challenge, you pick up as many credits as you can, and then you go back to wherever you were going to school and finish up.
Right.
I think it's a nice option, right?
It is really good.
Yeah, but I'm talking all this stuff about the challenge, and Dad's like, well, that doesn't sound like the program we heard about. So we started looking into it. It's like, oh, they got a new part of it. Yeah.
That's actually.
So what have you been doing since you got out of the challenge?
I was working at a factory for a while, but I was still young at the time. I graduated around 16, 17.
Yeah.
I wasn't ready for a hard-working job like that, decided I want to keep my body good, fresh.
Mhm.
So then I was working Little Caesars pizza stuff for a while. Then I finally talked to my dad. While I was associated with pizza, I was working at the airport janitorial.
Yeah. No fun.
Wasn't a fan, but it was
Yeah.
so kind for me. And then I talked to my father. He got me installing phones. Now I got a commission job making.
You're doing well. Good. So when you went to the challenge, did you end up with a diploma or GED?
Diploma, sir.
Good for you. Yeah. So where are you living?
Beach, and
Here-
Taylor.
Here's what I want you to do. We'll get back to business in a minute. Before you leave the building, I want you to go down. You remember Mr. Taylor?
I've seen him. Yes.
All right. Did you say hi?
I was going to, but I had.
I want you to go make contact with him and make sure he has your contact information,
Yes, sir.
because we might tap you to give somebody a sales job.
Yes, sir.
When I got some kid that's kind of teetering that I think he needs to go to the challenge and he's not really convinced,
I would love to do that.
I can tell. I can tell. Yeah. Because it made a big difference for you.
Yes, sir.
Yeah. That's awesome. All right. You made my day, week. It doesn't matter what happens tomorrow. You made my week.
I'm happy you didn't remember when I came in last time, sir.
Yeah. All right. Anything before I sentence you on this one?
No, sir, I appreciate you.
Okay. All right. All right. I'll just do fines and costs on this one. $350. Can you pay it today or do you need options?
For options, sir.
Figure it out downstairs.
Yes, sir.
All right. All right. So you started yes, sir, and a no, sir, and I was gonna ask you if you've been to the military. Now I know that came out of the challenge.
Yes, sir.
Good for you. Good for you. Always helpful. All right, go down, see Avery. You as well. Cleon Ellis.
All right, that's Judge Oakley. Interesting to see what's going on there. Good to see some redemption stories every once in a while here on TCF. That actually does happen. Yeah, I know. It's hard to believe, but maybe we'll get another one here right now as we head to Texas. Let's see what's happening in Judge Boyd. She's got another contestant coming on down, so let's see what's going on over here.
All right.
On the record.
I need everyone to, thank you. Court is calling 2025 CR 011020, 2025 CR 011311C, 2025 CR 011309A, State versus Adrian Isaac Hernandez. Can I have parties announced for the record?
Melissa Christian for the defendant.
And are you Adrian Isaac Hernandez?
Yes, ma'am.
Counsel, in each of the cause numbers, have you received all discovery and did you review it with your client?
I have, and I have done so, yes.
And each cause number, the court will find that the state is in compliance with discovery. Mr. Hernandez, in each cause number, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
And each cause number, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
State, in the cause number ending in 20, are you proceeding on the indictment as presented?
Yes.
And the cause number ending in the letter C, are you proceeding on the indictment as presented?
Yes.
And the cause number ending in the letter A, are you proceeding on the indictment as presented?
Yes.
Mr. Hernandez, in each of the cause numbers, did you review the documents entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
And the cause number ending in 20, you're charged with collision involving an injury. The range of punishment is not more than 5 years in the prison or up to 1 year in the Bexar County Jail, and a fine not to exceed $5,000. And the cause number ending in the letter C, you're charged with aggravated robbery. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. And the cause number ending in A, you're charged with aggravated robbery. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
And each cause number, if you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
And each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering these pleas, you're giving up those rights. Did you intend to give up those rights and enter into plea bargain agreements in each of these cause numbers?
Yes, ma'am.
In the cause number ending in 20, if the court were to grant your application for deferred adjudication, you could, and if for any reason your deferred adjudication were revoked, you could be sentenced up to 5 years in the prison. In the other cause numbers for the aggravated robbery cases, if the court grants your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court will be able to sentence you up to life in prison and up to a $10,000 fine. Did you understand? Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do believe.
Mr. Hernandez, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In the cause numbers ending in C, N, A, according to your plea bargain agreement, punishment is to be assessed at a cap of 12 years in the prison. There's a $2,000 fine, affirmative finding of deadly weapon. The state is opposed to your application for deferred adjudication. All of these cases will run concurrently, including the motion to revoke, and the state will take in consideration 2025 CR 0113110C and 2025 CC 009777. And the cause number ending in 20, according to your plea, punishment is to be assessed at 5 years in the prison. There's a $2,000 fine. State is opposed to your application for deferred adjudication. All of the cases will run concurrently, and the same cases will be taken in consideration that were previously stated. Did you understand that to be your plea bargain agreement in each of these cause numbers?
Yes, ma'am.
State,
Yes.
defense.
Yes, Judge.
In each cause number, did you review the waiver of appeal paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counselor, are there any such motions?
There have been motions filed, but nothing that would qualify.
All right, then in cause number 2025 CR 011020, how do you plead?
No problem.
And cause number 2025 CR 011309A, how do you plead?
No contest.
And cause number 2025 CR 011311C, how do you plead?
No contest.
State any evidence to support the defendants, please.
The state states one in attachments in each. And we have no objection in each case.
All right, state you may be excused. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it at all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
It's a lot of information for Judge Boyd to review here, so this could be a little while, but we have not lost audio. She's just reviewing 2 aggravated robberies and a collision. So a lot to unpack with this case, that's for sure. You know, seeing the kind of festive Judge Boyd purse flower combo kind of reminds me you can always go to courtroomfiles.com and get your Courtroom Files Christmas merch. Just thought I'd throw that in there.
In each cause number, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. We'll be back on January 26th At that time, the court will make a decision based on your applications based upon any evidence that is submitted. Counsel, is there a need for a mental health evaluation or no?
I don't believe so, Judge. We will have live witnesses on the 26th.
All right, thank you.
Thank you, Judge. I
Thank
would
you.
excuse.
Yes, you too. Yes. And then, Ms. Abrams, we'll take up the motion to revoke at that time.
Yes, John, preparing some more, please.
All right, thank you.
Well, that was certainly interesting. Again, 2 aggravated robberies, facing life in prison on 2 different charges there, and then up to 5 years on another. So we will see how that plays out in January, perhaps. It's the Courtroom Files Live. It is Thursday. Michael Groff filling in for Dan Soul, who will be back tomorrow. Let's see. Where do we want to go? You know, let's see. Where? A lot of places that we don't normally go here, and I kind of want to venture there, but I do see that, oh, we got Boyd here. Judge Stevens here. Boy, oh boy. Well, let's go and see what's going on with Judge Anna Garcia. Haven't checked in with her in a while.
Please.
Tevin Bellamy.
Mr. Bellamy, good morning. Come on up. Mr. Bellamy is coming up in Jackson County case number 21 CF 261. Mr. Bellamy, hello.
Hey, good morning.
Good morning.
Judge, we've got Mr. Bellamy here. I've been talking with Mr. Mitchell on the case, and he's in agreement. If we could just pass this to the 8th, there are some situations here regarding his community service work hours.
Sure.
One thing he did ask, though, because of what he heard a while ago.
Sure.
And I'll go ahead and tell the court what the problem is. It's because of the nature of his underlying offense.
Wait. Hold on. We can take care of it. Let me look at something. When was he put on? 21. When I came on the bench, I stopped requiring community service hours because we understand the very significant issue that is a result.
He has not been able to.
Hold on.
He wanted to know if he could do it at his church instead, but I get it.
No. If we recognize that. Is that the only reason, community service?
I think he still owes some financial stuff, Judge.
His loan violation is that he left his residence without permission. This was the big lot.
Sure, no, but I recall that. Yeah. But we also have. Yeah, I get that. And the recommendation was a notice to appear. Look, we can take the community service off. I think in 23, Jake, I started taking off community service hours for certain offenses because it's virtually impossible for them to do that. Sir, we don't want to set people up to fail. And so that's not the intent. And so the court today in Jackson County case number 21 CF 261 is removing the requirement that the defendant complete any community service hours as a condition of probation. However, there still remain some court costs. Are we going to try to get some of those paid after a minute?
Yeah, I think he's going to try to catch up, Judge. And also there is another, to deal with the other violation condition number 16. Mr. Mitchell's going to probably get me something on that. We may be working toward a modification of some sort. I don't know, but that was my client's biggest hang up was the community service.
Not being able to do.
He was very concerned about that because he's tried.
Sure.
And I've spoken with a significant other, and she's also verified that he has really tried to do that.
We understand.
So we can bring him back on the 8th, and then by then maybe we'll have something hammered out with the state, and we'll be ready to go to plead him.
So your next court date, sir, is January the 8th at 8:30 a.m. and I will see you then. All right. Thank you. Thank you.
We're bringing Fiona Best back out.
Oh, excellent.
All right, man. Try to pay that money, okay?
Miss Fiona Best is coming back out in Jackson County case number 24 CF 410. And Mr. Mitchell, what's the Bay County case number?
The Bay County case number is 242750 CF.
Okay. And so Jake, sometimes what we do is we'll let the clerks know that we have another county, and then they'll tell us, okay, they're ready, because they take the notes for the other county.
I got you.
Ladies, you ready? All right. Thank you, ladies. Ms. Bess, it's my understanding that you wish to withdraw your previous denial of the violation of supervision and admit that you violated the terms of your supervision in Jackson County case number 24 CF 410 and 24 CF 2750 in Bay County. The agreed upon resolution with the state is my understanding that both of your supervisions be modified, that you enter and successfully complete an inpatient drug treatment program, followed by the remainder of time on your supervision. All of your prior incomplete conditions of your supervision that I've not modified herein would be reimposed. Is that your understanding about a resolution?
Yes.
And is that the agreement with the state in both Bay and Jackson counties?
Yes, Your Honor.
All right. Does the defense stipulate to a factual basis for purposes of the admissions? Ms. Bess, if you will, please raise your right hand. Ma'am, do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, ma'am. You can put your hand down. Tell me your full name for the record.
Fiona Bess.
Ma'am, did you hear the announcement that the court just made about resolving your case?
Yes.
Is that how you choose to proceed?
Yes.
Has anyone promised you anything other than what was announced to get you to do this?
No.
Is anyone threatening you?
No, ma'am.
I have in front of me a one-page plea form for Jackson County. Did you sign that document right there?
Yes, ma'am.
I also have a one-page plea form for Bay County. Did you sign that document right there?
Yes, ma'am.
Did you have enough time to review both of these documents before you signed them?
Yes, ma'am.
Have you had enough time to talk to Mr. Green?
Yes, ma'am.
Are you satisfied with his advice and counsel thus far?
Yes, ma'am.
Do you understand that by entering into these admissions, you are giving up your right to go to VOP evidentiary hearings,
Yes, ma'am.
where the state would have to prove you did what they say you did?
Yes, ma'am.
Do you also understand that you're giving up your right to present any defenses that you may have?
Yes, ma'am.
And do you understand that you're giving up your right to appeal anything except an illegal sentence?
Yes, ma'am.
Are you doing this of your own free will?
Yes, ma'am.
Mr. Green, do you stipulate? Oh, I think I've already asked you that. Ms. Bess, do you know where you wish to go to inpatient drug treatment?
Aware.
Do what?
Aware.
Aware?
R. Keaton and Tallahassee.
Any of those? Okay. All right. Then I will, I find that your plea is knowingly and voluntarily entered into after the advice of counsel, and that there is a stipulated factual basis for purposes of these admissions. I will now proceed to sentencing unless I hear otherwise from either the state or the defense. Amber, can you tell me whether or not how much time we have left on both of those supervisions? I've got case number 24 CF 410 and 24 CF 2750 out of Bay.
Both 36 months terms total. on both.
Each of them? Okay, perfect. So we're going to have enough time if there were 24. All right. So ma'am, in Jackson County, case number 24 CF 410, I accept your admission to the violation of supervision. In case number 24 CF 2750 out of Bay County, I accept your admission to the violation of supervision. Counsel's has she been previously adjudicated guilty?
She may have in the misdemeanor case in Washington County, but I don't know about priors. Let me double check.
She was already adjudicated here.
Okay.
What about in Bay? Let me see what I find in Bay. Oh, crud. I'm in the wrong ICMS for 24 CF 2750.
I might be able to find it right quick.
I also need to see if there's a warrant.
There is a capias in the Bay County case.
Because I'm going to have to rescind that
Okay.
too. Those are things to note. That way she won't go there to the inpatient with a capias still. All right, let me see if she was adjudicated guilty in Bay County. Do what? Hun?
I'm showing adjudications of guilt on both.
On both? Okay, fair enough. All right, so you've already been adjudicated guilty, ma'am, in both of those cases. Your supervisions are modified. I will order you as a special condition of your supervisions for you to enter and successfully complete an inpatient drug treatment program, followed by the remainder of your supervision. All of your prior incomplete conditions of your supervision that I have not modified today are reimposed, except that if you go to a Ware or Keaton, any state-run program, that will satisfy the outpatient requirement. You won't have to go to inpatient, then do outpatient again, okay?
Yes, ma'am.
Do you have any questions for me about the sentence that I've just imposed?
No, ma'am.
Is there anything further from either the state or the defense?
No, Your Honor.
All right, then Ms. Bess, I'm required to tell you that if you wish to appeal this court's judgment and sentence, you have 30 days within which to do so. If you cannot afford an attorney, one will be appointed to you for that purpose. Madam Clerks, in Bay County case number 24 CF 2750, please show that capias as rescinded in light of this admission that is entered here today. All right, good luck to you, ma'am.
Mama Joan, Grandma TCF, thank you for the $5 super for, well, not Sabrina. Sabrina is Ashley's cat. Freya is our cat, but they are all chaos beasts in their own right. Ellie, Io, Freya, Sabrina. You can see how they all kind of blend together. But anyway, thank you so much for the $5. I really do appreciate that. Michael Groff filling in for Dan Soul here for a few more minutes, but I wanted to go someplace we don't go too often here on TCF. But let's go over to Judge Wheeler, Battleground, Washington, see what's going on up there this morning before we close things out for the day.
And Mr. Busby, please.
Thank you, Your Honor.
All right, sir, can I have you state your name and date of birth, please, for the record?
Caleb Whipple, 10/21 of '02.
Mr. Whipple, you're making your first appearance arraignment on a charge of negligent driving in the first degree. It's a simple misdemeanor, subject to 90 days in jail and a $1,000 fine. I did review the associated police reports with the case. I did find what is called probable cause. Because this is a criminal charge, sir, you have several important rights today, including the right to remain silent, the right to a speedy and public trial, and the right to an attorney. Would you like to be screened today for a court-appointed attorney? Are you planning on representing yourself or hiring an attorney?
Just myself.
Okay. Would you like to enter a not guilty plea so you can talk to the city attorney?
Yes.
All right, we're going to enter a not guilty plea. I'm going to schedule 2 future court dates. The first is going to be on the 18th of December, 2025, and that's going to be at 2 p.m. You can be in person that day or on Zoom, but you do need to be present.
Right.
If the matter does not resolve that day, we're going to schedule a readiness hearing for the 22nd of January, 2026, also at 2 p.m.
All righty.
Your release conditions are to violate no laws, appear at all mandatory court dates, notify the court of any change of address or phone number, not to consume or possess any alcohol, non-prescribed drugs or controlled substances, and not to drive without a valid license and insurance. I'm going to be releasing you on your recognizance. So the city attorney can be in touch with you. Is there a phone number I can write on the form here?
Yeah, 458-803-1984.
Okay. So Mr. Whipple, we're going to get you some paperwork at the far desk by the door. We're also going to, Miss Sass from the city attorney's office is going to get you some contact information for their office, okay?
Alrighty.
All right, thank you,
Thank
sir.
you.
Yep. Brian O'Neill. Hello, sir. Can I have you state your name and date of birth for the record, please?
Brian O'Neill, 022667.
Mr. O'Neill, you're making a first appearance arraignment on a charge of driving while suspended in the 3rd degree. It's a simple misdemeanor, subject to 90 days in jail and a $1,000 fine. I did review the associated police reports with your case. I did find what is called probable cause. Because this is a criminal charge, sir, you have several important rights today, including the right to remain silent, the right to a speedy and public trial, and the right to an attorney. Would you like to be screened today for a court-appointed attorney?
No, sir.
Okay. Are you entering a not guilty plea and would like to talk to the city attorney?
Yes, sir.
Okay. I'm going to enter a not guilty plea. I'm going to schedule 2 future court dates. The first is going to be that pro se pretrial date on the 18th of December, 2025 at 2 p.m. You can be in person that day or on Zoom, but you do need to be present. If the matter does not resolve that day, we're going to schedule a readiness hearing for the 22nd of January, 2026, also at 2 p.m. Your release conditions are to violate no laws, appear at all mandatory court dates, to notify the court of any change of address or phone number. You're not to drive without a valid license and insurance, and I am releasing you on your recognizance. So the city attorney's office can be in touch with you. Is there a phone number I can write on the form?
360-932-5951.
Okay. So Mr. O'Neill, we're going to get you some documents at the desk by the door. We're also going to get you some contact information for the city attorney's office. Once you have your paperwork, you are free to go. Thank you, sir. Patricia Enneking. Hello, ma'am. Can you state your name and date of birth, please, for the record?
Patricia Enneking, 10/22/79.
Ms. Enneking, you're making a first appearance arraignment on a charge called injury to person or animal. It's a simple misdemeanor subject to 90 days in jail and a $1,000 fine. You reviewed the associated police reports with the case. I did find what is called probable cause. Because this is a criminal charge, ma'am, you have several important rights today, including the right to remain silent, the right to a speedy and public trial, and the right to an attorney. Would you like to be screened today for a court-appointed attorney?
No, Your Honor.
Okay. Are you planning on hiring an attorney?
No.
Are you planning on representing yourself and talking to the city attorney?
Yes.
Okay. We're going to enter a not guilty plea to facilitate that. I'm going to set 2 future court dates. The first is going to be on the 18th of December, 2025. That's going to be at 2 p.m. You can be in person that day or on Zoom. If the matter does not resolve that day, we're going to schedule a readiness hearing for the 22nd of January, 2026, also at 2 p.m. Those are both mandatory court dates. Your release conditions are to violate no laws, appear at all mandatory dates, notify the court of any change of address or phone number, and I'm releasing you on your recognizance. So the city attorney's office can be in touch with you. Is there a phone number I can write on the form here?
715-309-9215.
Okay. So ma'am, we're going to get you some documents at the far desk by the door. We'll also get you some contact information over there, hopefully for the city attorney's office. Okay?
Thank you. Your
Thank you, ma'am. Yep. Is this the DeSanti matter? Okay, thank you. Let me take a look at this real quick. I think that I already had done probable cause on this from the time I issued the warrant, but let's take a quick look. Yeah, probable cause had previously been found. Mr. DeSanti, can you hear the court, sir?
Yes, sir.
Sir, you're making a first appearance arraignment in the Richfield Municipal Court on a August 27th, 2025 charge of theft in the 3rd degree. That charge, sir, is a gross misdemeanor. It's subject to 364 days in jail and a $5,000 fine. I did review the associated police reports back in the month of August. Looks like in October. Looks like on October 15th, 2025, I did find probable cause. Your attorney, Mr. Wallace, is with us here in the courtroom. Go ahead, Mr. Wallace.
Thank you, Your Honor. Mr. DeSanti would like to enter a not guilty plea, waive a formal reading, and address release conditions.
Okay, not guilty plea is received. I don't have Mr. Busby here, but let's discuss release and see where we land.
Okay, thank you, Your Honor. I saw that in the file, there was a recommendation from the prosecution to entail $3,000 bail and intensive release. I'm not sure if that was the previous recommendation or if that was modified for the current set of circumstances, but we would ask that the court impose bail in the amount of $500, a nominal amount. And if Mr. DeSanti is able to meet bail, we'd ask for administrative release so he doesn't have to check in person, but rather could do so by phone.
I think administrative release is on phone. I think.
Yeah, that's what I meant to say.
Okay.
If I didn't.
Gotcha. That's fine.
Yeah.
Okay. So it looks like there was originally, at the time of this incident, a recommendation for 3,000 bail. looking at the DCH that I'm able to see right now, I can see absent our case, 5 additional warrants. It looks like, at least from the documentation that we have as well, there is a warrant from 2022 in the state of Oregon. So that would put us at 6 warrants. A significant felony history regarding crimes of dishonesty, similar to, unfortunately, this circumstance. So the court will reduce the bail. I'll impose bail in the amount of $1,500. I do think, due to the amount of additional warrants, that amount would be to preserve Mr. DeSantis' reappearance. Based on that bail, when would you like the court to set the next date?
Could we set it out 2 weeks, Your Honor, please?
Okay. All right, so we're going to schedule this matter out for our December 18th court date. Mr. DeSantis, the court date on December 18th, 2025 is going to be at 10 a.m., but if you are in custody, sir, they will bring you over earlier. Your release conditions, sir, to violate no laws, appear at all mandatory court dates, to notify the court of any change of address or phone number. You're not to have any contact with Tractor Supply. And if you do end up posting bail, you are on administrative release with Clark County pretrial release. That involves just telephonic check-ins. Do you have any questions, sir, regarding the court's rulings today?
Yes, sir.
Sir, that concludes your hearing.
Thank you, Your Honor.
Thank you.
All right, folks. Normally, I would just say, let's wrap it up there. But 'tis the season. I'm here. I'm filling in. I have a little extra time. Why not? I've already done my work for the day today. So how about a few more minutes? We'll wrap it up. He's in the holiday spirits as well. Let's go back over to Judge Simpson. Let's see what's going on over there.
Round will continue. Thank you. Court calls the cases of the people versus Thomas Vasher. 3 cases.
Purposes of public defender, Marshall Feaster, on behalf of Mr. Vasher, who is approaching the podium. Mr. Vasher, when you arrive, please state your name for the record.
Thomas Vasher. Thank you. Yes, Your Honor.
Thank you, Judge. 2 of Mr. Vasher's 3 cases have been up previously. The third one, this is the first date for the third one, I believe.
Got it.
Mr. Vasher's already been screened for drug court. We're waiting for the report to come back as to whether or not he's accepted. So I'd ask for a 2-week adjournment to see where we stand on his.
And that is felony drug court?
Correct.
It is, Your Honor, and then the new case is an RNO, so it may throw a wrench into drug court, so.
Okay. But we'll know at the time of.
I hope so, because it's an older case, it's just newly authorized.
All right.
Don't worry, relax. Let's find out what drug court says and then we'll go from there.
Thank you. December 18th, 2025, 9 a.m. Bond continued.
I apologize, Your Honor, I had it backwards, it's a different case, we'll still see what happens.
Okay.
That was December 18th, Judge.
18th.
Thank you very much, Judge. And I will. Gotcha. Relax.
Court calls.
I'll submit an order, Judge. He's seeking inpatient treatment as well.
All right.
Thank you, Judge.
Court calls the case of the people versus Christopher Walker.
Assistant Prosecutor.
Assistant Public Defender Davey Lebo on behalf of Mr. Walker. Now, Mr. Walker will be waiving his exam, and I do have the form for him to sign here. Waive the exam, sign there. And I have reviewed the rights with Mr. Walker. He is aware of them, and he would like to waive his exam.
Sir, you're waiving your right to a preliminary examination? Yes, sir. You understand that that's a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it?
Correct.
You understand that? Sir. You understand you will not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
People do wait, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on count one with two following.
Thank you, Your Honor. We acknowledge receipt of the information, waive formal reading and stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea as to both counts. Pretrial will be set for
December 17th at 1:30 with Judge Conlon.
December 17, 2025, 1:30, Judge Conlon.
Thank you, Your Honor.
Bond continued. Court does call the cases of People versus Matthew Wallace. Three cases.
Assistant
Commissioner on behalf of Mr. Matthew Wallace is approaching. Mr. Wallace, state your name for the
Mr.
record.
Wallace.
Matthew Wallace.
Thank you.
I need your signature here. Your Honor, we're going to be doing a waiver today.
I'll move the cases.
That's correct, Judge.
All right. Sir, you understand you're waiving your right to a preliminary examination?
Yes, sir.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand that you will not have that hearing and that you'll proceed to circuit court for further resolution of these matters.
Yes, sir.
You understand that? People also waive their right?
Yes, sir.
Preliminary examination having been waived, defendant is bound over to circuit court on actually one count in each case with two misdemeanors following.
Well, we acknowledge receipt of the information, Your Honor, standing mute, asking the court to enter a not guilty plea and waiving formal reading.
Defendant never waived formal reading, standing mute. Court will enter a not guilty plea as to all counts. Pretrial in this matter will be set for
December 17th at 1:30 with Judge Conlon.
December 17, 2025, 1:30, Judge Conlon.
Judge, we'd like to just, I guess, put the court on notice. We'd be sending over a release to treatment. I know the court is typically, we have,
Well, I'd have to order that today, but
I can get it
is there
to
any
you today.
objection to release to treatment?
Thursday.
All right.
I can
Release
get
to
that up.
treatment, it needs to include the GPS thing, but you got to get that over to me, otherwise you're gonna have to get that.
Do it today, Judge.
Thank you.
Matters found will continue. Oh, go for it. Court calls the cases of the People versus Deidre Woods, two cases.
Assistant Public Defender Chinazi Carey, I can rule Your Honor on behalf of Ms. Deidre Woods. Ms. Woods, state your name for the record. Deidre Woods. Your Honor, we do have a plea. I just need her to sign. You good to go?
We have a what?
A plea. We haven't, we've reached a resolution in this matter. She'll be entering a guilty plea to, on the 5847 matter, and added count 3 of larceny, 200 to 1,000. And then on the 580,
Do I have the forms?
she's signing them, Judge. Sorry, Judge. Yeah, right there. Okay. Thank you, Honor.
All right, I now have two plea forms in front of me. The one first indicating in the 5847 matter that the defendant would be pleading to an added count 3 of larceny, 200 to 1,000, the 1-year offense. Upon our successful guilty plea to that charge, count 1 and 2 would be dismissed. That's the court's full understanding of that agreement. In the other matter, the case ending in 5803, the court's understanding she's going to be pleading guilty to the charge of false pretenses, 200 to 1,000. That's an added count 2. The 1 year offense. So it's false pretenses, 200 to 1,000, the 1 year offense. Upon her successful plea to that charge, count 1 would be dismissed. That's the court's full understanding in that case.
That is correct.
That is our understanding as well, Judge.
May I have her sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give, the whole truth and nothing but the truth, so help you God.
Yes.
State your name, please.
Theophilus Woods.
Ma'am, it is this court's understanding that you are going to be pleading guilty to 2 misdemeanor charges. Is that your understanding?
Yes, sir.
All right. First, in the case ending in 5847, it's a charge of larceny, 200 to 1,000. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased 3 times the value of the property stolen or subject to the theft. If that's greater than $2,000, that becomes the maximum fine. You understand that, ma'am?
Yes.
All right. In the other case, it's charge of false pretenses, 200 to 1,000. That has the same penalties of up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $500 or greater than $2,000, that would become the maximum fine. You understand that, ma'am?
Yes, sir.
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge. It's the same judge in both cases. And that you would be sentenced before the 15th District Court, before Judge Perry. You understand that?
Yes.
All right. Now, understanding all of that, do you still wish to plead guilty to these charges?
Yes.
To the charge of larceny, larceny, 200 to 1,000, how do you plead?
Guilty.
To the charge of false pretenses, 200 to 1,000, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
All right. You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you are indeed guilty of these offenses?
Yes, sir.
Starting in case 5847, on the date of August 16, 2025, at the location of 120 West Huron Street, room 417, what'd you do on that date that makes you think that you're guilty of that offense?
I took a bag near the elevator. It was like a purse or a bag, some type of bag.
Okay, what is this, a hotel?
Yes.
Okay, you went into the hotel and there's a bag unattended near an elevator
Yes.
and you took that bag?
Yes.
All right, and you kept or tried to keep some of the contents of that bag? Is that correct?
Yes.
Well, your intent was to keep it, right?
Yes.
All right. But eventually you got caught and you didn't end up keeping it, right?
That's correct.
All right. And was the value of the items that you intended to try to keep, was it in excess of $200?
Yes.
Can't get an iPad for $200, you know that. Yeah. All right. Let's go to the other case. And in the other case, which ends in 5803, on the date of August 16, 2025, at the location of 114 East William Street in the city of Ann Arbor, Washtenaw County, state of Michigan, what'd you do on that date that makes you think that you're guilty of the charge of false pretense?
I made an attempt to use a debit card, but he didn't swipe it. The transaction didn't go through.
Say again?
I made an attempt to use a debit card, but the transaction it didn't go through, so nothing was missing.
Okay, but where'd you get this debit card?
Out of the bag, out the purse.
Oh, okay. So the bag from the incident, then you then you took a debit card and you tried to use that debit card.
Yes,
All right. And you know you didn't have authority to use that card, is that correct?
yes, that's correct.
And you attempted, well, on that one, you didn't attempt to buy anything or get anything more than 200, did you?
No,
All right, but on that one, I would take the higher charge
thank you, Judge.
as a plea to the lower charge. Okay, ma'am, I do have to advise you that if between the time of my acceptance of your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, number one, you would not be entitled to withdraw your plea, and number two, that any sentence evaluation or recommendation the court would no longer be bound by. You understand that?
Yes, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Defense is not as well, Judge.
And have I complied with the court?
Defense is also satisfied.
Court will accept the defendant's pleas of guilty in the case ending in 5847. Her will accept a plea of guilty to count 3, counts 1 and 2 are dismissed. In the other matter, will accept her guilty plea to count 2, count 1 is dismissed. In both cases, a pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in these cases will be December, say it again. December 19th, 2025, 8:30 before Judge Perry.
And Judge, can we address bond very
Briefly.
Yes, Your Honor. Last time we were here, the court did allow Ms. Woods to be released on a tether for the whole purpose of going over to Wayne County to resolve her Wayne County matter. Unfortunately, she has not done so because of the tether. With the resolution that we've reached on this matter now, I'd actually just be asking that the court allow her to be released on a PR bond. Wayne County is going to come and pick her up and put a tether on her for their matter.
Well, I don't know that I'd grant her PR at this time. I think her sentencing is coming up in a few days on the 19th. And I would leave that to Judge Perry.
It's already, I guess what we were asking for is if there was a possibility to remove.
Move the tether provision. Any response from the people? All right. You're gonna do what you're supposed to do?
Yes, Your Honor. Scout's honor. I promise.
Scout's honor? Are you a scout?
No.
Are you a scout? Why are you telling me Scout's honor if you're not a scout?
She said Jesus honor. Sound like.
Wow, really? You just lay down that big old trump card. All right, what I will do is on each of these cases, I'll continue your bond. I'll remove the GPS provision.
Thank you so much.
All
Your
right,
Honor.
so that she can go get her matters taken care of.
Thank you, Judge Simpson.
You're welcome.
Thank you, Your Honor.
All right. Well, that will just about do it. Yo, here I am. Hi. It's been one of those days. All right, that's going to about wrap it up for this edition of the Courtroom Files Live on a Thursday. Michael Groff been filling in for Dan Soul. A couple of things to remind you about, of course, if you've enjoyed what we've done here and you want to help support the channel, well, of course, by all means, do so one of the best ways to do that is to pick up some of that Christmas merch over at the Courtroom Files site there, courtroomfiles.com. There's the calendar. Actually, I think the calendar is probably the best bet. That's what I would go with for the merch. There's a lot of other cool stuff there too. All the holiday swag. There's some good stocking stuffers in there. There's some great gifts for someone that you care about. Someone else that maybe you want to make a certified law junkie. Maybe consider that this holiday season. Or anytime, really. Valentine's Day. What better way to tell someone you love them other than to get them some Courtroom Files merch? I mean, you could be certified law junkies together. I don't know what's more romantic than that. All right. That and Dan will be back tomorrow for a Friday edition. It should be a super, maybe even a super duper Friday edition of TCF Live. So thank you guys so much again for bearing with me. And of course, if you want to check out what I'm up to, of course, my channel over there, Michael Groff, and the Phoenix, Arizona weather discussion and all of that. Barbara posted the links earlier, and we really do appreciate that as well. Thanks again to Mama Joan, Grandma TCF, $20 plus $5. And according to my math, let me see. Hold on one second. Let's see. 20. Hold on. Carry the 3. Okay. $25 total there. Do appreciate that. Thank you again so much. Everybody, Wahoo, Lindsay, Ashley, Austin, Ronnie was in here earlier, Mama Joan, I don't know, everybody that joined, Barbara, of course, everybody that joined us in the chat today. I really do appreciate all of that. All right, we'll be back tomorrow. Well, Dan will be back tomorrow. I'll just be a rank and file in the chat, hanging out with you guys. Thank you so much, and we'll be back in that. Goodbye, everybody.